Looks like we're just about ready and we are streaming. So good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. This morning we have a number of work sessions on bills. We'll get to that in just a moment, but we're going to start with committee introductions. And again, if you don't mind, I'm just going to call on you in the order I see you on the screen. Starting with you, Representative Evangelos.
Good morning, Senator Carney. I was late, but I guess I'm not late. Sorry. Jeffrey Evangelos, House District 91. I represent Washington Friendship Union in Waldoboro. I live in Friendship. Good morning.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty from House District 45, which is part of Gray and all of Cumberland.
Representative Babbage.
How do you do? My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative Sheehan.
Thanks, Madam Chair. My name is Erin Sheehan, and I represent House District 12 in Biddeford.
Representative Libby.
Thank you, Madam Chair. My name is Laurel Libby, and I represent District 64, which is part of Auburn and all of Minot.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison. I'm going to apologize in advance. I have a couple of other meetings I have to attend to this morning, so I will be in and out a little bit.
Representative Thorne.
Thank you, Madam Chair. Good morning from Carmel. I'm Jim Thorne, House District 103, which is Carmel, Herman, and a portion of Etna up in Penobscot County.
And this is going to sound ridiculous, but Representative Babbage, should I call you? I'm sorry, I'm not. I did. Okay, thank you. Senator Keim.
Morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
And Senator Sanborn.
Good morning, everyone. My name is Heather Sanborn, and I represent Senate District 28, which is half of Portland and half of Westbrook. And like Representative Poirier, I'm going to be a bit in and out this morning.
Thanks to you both for letting us know. I am Ann Carney. I represent Senate District 29, South Portland, Cape Elizabeth, and a little bit of Scarborough. And I am going to introduce our legislative analyst, Peggy Reinsch.
Hello, I'm Peggy Reinsch from the Office of Policy and Legal Analysis. You get just me today. Janet will be with you on another day.
And our committee clerk, Susan Panett.
Good morning. Pleasure to be here.
Thank you both. And so we will begin our work today by opening up a work session on LD 903. That is an act to enact the Uniform Foreign Country Money Judgments Recognition Act. And we have had one work session on this bill already. I think what I will do is just let people know the order of bills as well for those members of the public who are in the attendee part of the meeting. We're going to do work sessions on 903 and then 233 unless Representative Harnett is not able to join us when it comes up. 1831 will be next, 1900, 1871, and then 1918. And again, that may change a little bit depending on Representative Harnett's availability. And so with that, we'll open the work session on LD 903. And Peggy, did you want to start us off with the amendments?
I would be happy to, but if you don't mind, I would really appreciate it if you would bring Caitlin Wolf in. She is the attorney from the Uniform Law Commissioners, and Paul Chaikin and Justice Alexander are also Uniform Law Commissioners, and Justice Alexander had sent you a memo a while back about some other issues to think about. And he wanted me to clarify for you that that was from him as an individual and not from him as a uniform law commissioner. Uniform law commission is about uniformity. And so we wanted to make sure we're not getting those two roles mixed up. And I see Caitlin's here. She's my go-to person on this bill. So I'm happy if you remember, I'll just kind of recap where we were. You went through the whole amendment last time, which combines the Foreign Country Money Judgments Recognition Act with the Uniform Registration of Canadian Money Judgments Act. So it allows for the recognition of judgments about money from other countries, and it allows you to register a judgment from Canada. And the Canadian registration piece kind of overlaps or uses some of the process or the process that you would use for recognition of the foreign money judgments. You can always, even if it's a Canadian judgment, you can always use the Foreign Money Judgment Recognition Act to have that recognized as opposed to just registered. So I think we were down to just a couple of questions, and we wanted to make sure that everything worked for the judicial branch. So we used some of their terminology. Uniform law commissioners understand when we need to use consistent terminology. So we talk about motions rather than petitions in the Registration Act. And we took the standard form out because the judicial branch would prefer to do that through their orders or rules. So if I could just draw your attention to one thing that, oh, and you also asked for the act to take effect January 1st, 2023, both pieces of this.
Peggy, I am so sorry to interrupt, but I wasn't sure if you also wanted me to bring Justice Alexander and Paul Chaikin onto the panel or just Caitlin Wolf.
I think it would be nice to have them there in case you have questions for them. I'm not sure they have more to add. I think they've already provided their comments, but you might have questions for them.
Okay, I will bring them over. I just wasn't sure I was.
I'm sorry.
Thank you.
And I can share this latest draft with you if you'd like, or we can just talk about it. But one thing I do want to draw your attention to is something that you talked about last time. It's on this draft. It's page 6. It's section 8903, applicability. And one of the things we talked about was changing the judgment. This is under the Canadian Registration Act, changing the language. The Uniform Act says a Canadian judgment that grants both recovery of a sum of money and other relief may be registered under this act, but only to the extent of the grant of recovery of a sum of money. So there might be some other relief, but you're not registering that part. At the time, you talked about adding in denies, so that the judgment would grant or deny recovery of a sum of money and other relief. And what we weren't really able to talk about during the work session is that the Uniform Law Commissioners consider that a substantive change. And although it might have been in prior laws, it was debated by the Uniform Law Commissioners and decided not appropriate to include it in the Canadian Money Judgment Registration Act. So I wanted to draw that to your attention so you could think about whether you want to keep this piece of it uniform or if you wanted to go ahead with that change. And this is, I know that this is one of the things that Justice Alexander had suggested you think about. And also Caitlin Wolf is here who can give you more details about any of that. So I guess I'll pause there and see if you want to talk about that or if you have any other questions about anything else I've said.
Thank you. I think it might be helpful, Peggy, if you don't mind. I know that in the amendment that you circulated to us, you had sort of added a note in the section that you were just referring to. Do you mind screen sharing that? Because I think the visual will help us all.
Page 6. So this is the section we're looking at right here. Oops, is it not gonna let me? And so I included this little note, and actually I included the note throughout the amendment where there were suggestions from Justice Alexander that you either hadn't talked about yet or that were either substantive, what we were considering substantive, or really just language changes. So that's the information we're talking about. It's the Canadian Judgment Registration Act. And this is about preclusion of once you already have a judgment in Canada, does that preclude going forward in this state?
So the question for the committee on this point is, do we want to revert back to the uniform language, or do we want to continue to include this substantive non-uniform language? Is that it kind of the decision we're okay?
Yes.
So yeah, no, you presented it to us really well. And so committee members, does anybody have questions for Peggy or for Caitlin Wolf or for Justice Alexander on this point? Could you please use your electronic hand if you have a question? I am not. Oh, go ahead, Representative Babbage.
Oh, thanks. I would like Ms. Wolf to comment on what we've just discussed, just very briefly, if that's possible. In other words, should a Canadian judgment, I know that we're seeking uniformity, and usually we adopt 80 or 90%, sometimes 100% of what is recommended by the Uniform Law Commission. But I would like to ask Ms. Wolf if the addition of denies is inadvisable as a substantive change, or as compared to status quo. Thank you.
Yeah, thank you, Representative. And Caitlin Wolf, are you able to respond to his question?
Yes, thank you, Chair Carney. Can everybody hear me okay?
Yes.
We can, and good morning and welcome.
Thank you. I appreciate the opportunity to be here with the committee again. I appreciate your time and attention to this bill. And yes, so to address Representative Babbage's question, I regret that the last time I was with the committee, I couldn't provide you, more detail about this provision. What I've done since the last work session, though, is I've gone back, I've reviewed the commentary that the Uniform Law Commission drafted in conjunction with this section, and also consulted with the drafting committee chair, the individual who wrote the act as well. And essentially, I learned from them that this would be a departure that would be very significant from the Uniform Act. And in fact, the commissioners would not consider this a uniform adoption of the act if it were to move forward with this language. So what they address in the commentary and what they were thinking about in the drafting process of this act, they really truly did design this Canadian Registration Act for the purpose of registering and recognizing judgments when you're seeking to enforce those judgments. So specifically when you're trying to collect a sum of money. And they drafted this whole applicability section, so subsection 1 and 2, with that in mind. And something else that I did mention to the committee in our last work session was this whole Registration Act piece was drafted in a close working relationship with the Uniform Law Conference of Canada, one of our big goals in the project was, to the extent possible, to harmonize this act with the Canadian law on the subject. Taking a look at the Canadian law as well between the last work session and today, the Canadian law also is drafted, again, specifically for use when you're trying to enforce a judgment, when you're trying to collect on that foreign judgment. So sort of taking all of that together, in talking with the chairs, in reviewing the commentary in the act, in essence, we would strongly urge a return to the uniform language here. And I would just, again, for folks that aren't as familiar with sort of how these acts are used, this wouldn't harm the status quo. In essence, what would happen is, and what our drafters were thinking is, if you wanted to use that foreign judgment for preclusive effect, that would often come up in the lawsuit, in an already pending lawsuit under the Recognition Act. So under your existing law, you already have to file a lawsuit, like we've talked about a bit, and that's what would happen under the Recognition Act. So that status quo would essentially remain. And then what we're talking about here is this new registration procedure that would go into effect would only be for folks who are trying to register and collect on that money judgment. I hope, Representative Babbage, that answers your question. I'm happy to go into more detail or answer other questions, but I do appreciate the opportunity to comment.
That was a wonderful answer. Thank you. I appreciate it.
And so committee members, given the explanation that we've just heard and all of the follow-up research that was done on this, is there anyone who would like to make a motion that we strike the language we added at our last work session and maintain the original language that was proposed in the amendment? So that would be striking the words ordinize and ordinile from section 2 of subparagraph 2 of section 8903. Representative Moriarty?
Thank you, Madam Chair. There are a couple of other places where we have italicized language. I'm looking at page 4, for example, under section 8806. And I don't know if that is language, well, whether there's some sort of option to go with an earlier recommendation or to proceed independently.
Okay, let's ask Peggy to clarify that. I thought it was because we had specifically adopted the denial language, but not the other changes. Peggy, could you help us with that, please?
Sure. So what is in italics are things that you actually approved at your last work session. And when the uniform laws are put together, they recognize that there are certain kind of internal procedures. So I mean, Caitlin has looked at this pretty closely, and she doesn't think, like, for example, in section 8806, where it talks about commencing an action in compliance with the main rules of civil procedure, that's a non-uniform provision. It's how Maine starts a lawsuit seeking recognition of the foreign country judgment. And this is language that the judicial branch suggested would work for the judicial branch's purposes, and it would be clear for anyone who's filing a lawsuit. So anything that's in italics, you have actually already, you approved. What this draft also shows is I've indicated, Justice Alexander spent a lot of time looking at it and identifying some additional issues that you might want to consider. So he had a separate memo, and that he submitted on, not in his role as a uniform law commissioner, but it raises issues that as a practitioner in Maine, he thought about, and I flagged those for you in this draft with so you need to go back and look at his memo. But for example, he suggested one more form of, I think this is personal jurisdiction. Oh, it's not recognized. It's when the state may not recognize. The state may not recognize something. He's got a suggestion for you there, and discretionary non-recognition here. And we can go back and look at his memo and identify those. And there might be one or two other places. But what I wanted to do was flag those for you so you knew that there were things that you hadn't talked about, but that Justice Alexander had suggested that you might want to think about. I don't mean you need to force, I'm not trying to force you to do anything, but those are just some suggestions that are out there. Is that helpful to your question?
Yes, but a quick follow-up, if I may.
Yeah.
All of the italicized language we have previously approved, but the only italicized language that is out of sync with the uniform law is that on page 6 dealing with denials.
That's my understanding. And if Caitlin Wolf could confirm that, that would be great.
Yes, if I may. Peggy, yes, I believe that's correct. There is one other, the transitional provision on page 10. Peggy, I just want to confirm with you. That's section 8911. I see that that was a suggestion, but that was not yet adopted by committee. Is that right?
I think,
or was
I
it?
think that's right.
Okay, then yes, then that's correct. And if I may, the italicized language that was suggested by the judicial branch, just to confirm, the Uniform Law Commission is 100% supportive of those suggestions and those changes to ensure that this works appropriately for the court system. So we would be in support of those suggestions that the committee did adopt. So no issues there.
And so the only issue is with the one that you had described to us earlier. Is that correct?
Yes, Chair Carney. Yes. So the issue that I just talked about, the sort of preclusive effect language that the committee adopted in the last work session, that is a central sort of policy decision, a central issue for the Uniform Law Commission that I did, as I said, go back and reviewed. So that would be problematic from a uniformity perspective. And that's the only sort of policy decision that I wanted to ensure that I spoke to you about again today. And again, I'm here if you have questions about the uniformity of other suggestions or other changes, we can go into those. I just didn't know what the committee was going to focus on today.
Okay, thank you so much. So I see a couple of hands up. Representative Moriarty, go ahead.
Thank you, Madam Chair. I don't mean to be a nuisance, but I wonder whether in fact we have adopted anything, in that at the previous work session, we concluded with a motion to table. So I'm not to be sure that we're on the straight and narrow. I'm not sure that we have actually adopted or recommended.
That's probably true. I'm probably using the approval language a little too loosely. Okay. I think that you discussed it and I said I would incorporate it, the denial language, as well as identify the other suggestions that Justice Alexander had made, so you would have an idea when you had this work session.
Okay.
And that hopefully all your questions would be answered.
Thank you. Representative Babbage?
Yes, if I may, I don't think we need to spend a lot of time on this perhaps, but I think we're getting there. My question to Ms. Wolf, if that's allowed, Madam Chair, is on page 7, would that in fact avoid needless expense if we included the shaded language on page 7?
Thank you for the question. Caitlin Wolf, you can answer if you're able.
Thank you, Chair Carney. Yes, so just to make sure I'm tracking right, Representative Babbage, on page 7, are you referring to Justice Alexander's suggestion for a court-prepared copy of the? Yes, 100% in support of that. I think that would result in cost savings, so I think that would be a wise addition to make to the bill. Absolutely.
Thank you.
Committee members, any other questions for Caitlin Wolf? Go ahead, Senator Keim.
Thank you. Yes, Ms. Wolf, I have a few different questions. So one of them is New Hampshire and Vermont never adopted either the old or the updated Foreign Money Act. Can you help us understand why they would not have?
Sure. So, as you may know, we do promulgate multiple uniform acts every year at the ULC. So it's a little bit different. What we typically do is we work in close conjunction with our commissioners from the states to see which acts they're interested in pursuing in their home jurisdictions. And with respect to this act, in particular, the Recognition Act with those states, I don't know that there's a particular reason why they haven't adopted them yet. I think perhaps just focusing on other uniform acts. I know in New Hampshire and Vermont specifically, I've been working with them on adoption of another uniform act right now. So I think it's often just a matter of bandwidth and which uniform acts capture the attention of our commissioners. So I wouldn't think that it's a judgment of the merits of the act or anything like that. I think it's often a matter of bandwidth and what our commissioners are most interested in working on. So I hope that helps.
Yeah, I guess so. Then it would just bring me to wonder, why are the commissioners most interested in working on this specific uniform act here in Maine? Like what brought this to the level of your attention here?
If I may, Chair Carney, that may be a better question for Commissioner Paul Chaikin. I think, Paul, you put this on your sort of agenda. If Paul could address it, if that's appropriate.
That is, go ahead, Paul Chaikin.
Thank you, Madam Chair. This one caught my attention for two reasons. It was a fairly recent enactment by the ULC, but more particularly with Justice Alexander having been appointed the third commissioner and he having had a lot of experience sitting on the bench in Washington County. I thought it was a good introduction to him as to the inner workings of the Uniform Law Commission. So it just happened to be the adoption of the act and the appointment of Justice Alexander. As to the earlier question, if I may, in terms of what we commissioners choose to do, Caitlin is right. A good description is what bandwidth we have. We're all volunteers, and we have other commitments that we do. So we cannot attack we cannot pursue every uniform act each year.
Thank you for those answers.
Yes.
Did you have a follow-up question, Senator Keim?
Yes, I have several.
Go ahead.
So, and this may have a similar answer, but I don't, in some ways I enjoy seeing Maine be first in things, but in a lot of ways I'd much rather see how things work out other places than be the first to jump in. So the Canadian Money Judgment Act has only been introduced in one border state, which is Minnesota, if I'm correct. And I'm wondering if you know why that is. Because other border states have adopted the updated version of the Foreign Money Act, but not the Canadian Act as well. So I'm just wondering if there's hesitation in other states and if you know what that is.
I'm going to have to defer to Caitlin on that. I don't have the information.
Mhm. Chair Carney, I'm happy to address that if you'd like.
Yes, please do.
Sure. So I think Senator Kime, one of the big things to note about the Registration Act in particular, that seems to be the one you're most curious about. So it was finalized by the ULC in 2019. So it's only been available to the states in a couple of legislative sessions, all of which have been during the pandemic. So I think just as Maine has grappled with the pandemic and the crisis and having limited bandwidth to address issues, it just hasn't been a top priority, I think, for a couple of these other states. We've seen a lot of activity on other uniform acts over the past couple of years as folks have tried to grapple with remote notarization, electronic wills, and some other issues. So again, we ultimately defer to our commissioners in the states about what it is they want to pursue in a given session. And a couple of those other acts have, I think, just taken priority. So it's my hope to be able to work with more of our, certainly the border states and really any other state that's interested in the Registration Act piece going forward. But I think that's sort of what's happened over the past couple of years, just limited opportunity, limited time to work on these acts.
So given that, and I don't know which of you is most appropriate to answer this, but could you just give me again some examples of how you believe this benefits regular Maine people, and then how often these types of situations come up, because it's something I'm totally unfamiliar with.
I would ask Paul Chaikin, perhaps that's a good question for you. And Senator Kime, do you, I think it would also impact Maine businesses. And so do you mind expanding the question to Paul Chaikin to include people and businesses?
Sure.
Thank you. Go ahead.
Madam Chair, I'd actually, the one that probably could describe how it works into the judicial processes in Maine is Justice Alexander. It's been a while since.
Thank you for that suggestion. Justice Alexander, are you able to answer that question for Senator Kime?
I'll give it a shot. I actually think we discussed this a little bit the last time we had a hearing on this. And my own view is, from my experience, particularly as Paul mentioned in Washington County, there's all kinds of ways that people try to get judgments in for a wide variety of purposes. Businesses, individuals, both for and against businesses and individuals. This provides a significant clarification of how that can occur, which I think would be considerably beneficial. It's basically a how-to. Okay, you want to have this Canadian money judgment available, registered in Maine, official in Maine for this purpose. Here's a track of how you do it, as opposed to either using the Recognition Act, which requires a pending suit, or as opposed to using the rules of evidence, which effectively also require a pending suit to do that. Whereas you have a lot of situations where there might not be a pending suit, but you want recognition of judgment. For example, looking at credit applications, looking at security checks, being involved in things that are not involved in court actions, which is one of the reasons I suggested the granted or denial. You can have a number of situations where you do want a judgment to be considered and available. Let's consider, for example, a med malpractice screening panel, where there's no action filed, can't be filed till the med mal screening panel acts, or an arbitration matter, or which happens a lot in contracts that are involved in both individuals and small businesses, and this just provides a relatively simple, I thought, how-to as to how to do that for Maine people. It certainly would end some of the uncertainty I faced as a judge dealing with situations in Washington County, and I know other judges in Aroostook County have similar issues because of the very close relationships, cross-border relationships and personal relationships, families and all that live on both sides of the border, and businesses that regularly do business across the border.
Right, and thank you for that answer. And then, but how often are these types of situations coming up?
That in terms of court actions, I cannot tell you because we sometimes did it informally. For example, they've got this judgment in Canada, and you accept attorney's representation for it, things like that. In actual court, I didn't recall a large number of matters where we had an issue about a Canadian judgment that somehow was disputed, as opposed to simply somebody simply announcing it. But I know there are other types of actions too, as I said, where it could be important. Again, credit rating, making banking determinations, making loan determinations, making property, financing determinations, things like that. Though I say the decision that the commissioners had, which I only found out about, I was basically told only last week that no, you can't recommend these things. Although I'd been back and forth with Peggy and you folks on the committee on this for since the middle of last year. But anyways, that's why I changed my view to say this is only what only the view I take. That's what I was told I had to do last week on that. But anyways, I hope that's helpful, Senator Kime. I mean, it's a valuable how-to thing for people both in court and because this allows things out of court to do that.
Thank you,
Justice
I appreciate
Alexander.
that. I have one more question.
Okay.
So the other, so maybe this is for you as well, Justice Alexander, but so do we have something equal in Canada that they are also recognizing, and is that of benefit to, to Maine citizens? Or how does it work on the other side for foreign money judgments?
I am not familiar with a similar law in Canada. I do know that there's often, or there is from time to time, interest in American judgments and how that might be applied in Canada informally. For example, sometimes in cases that are pending in Canada and they're interested in getting information about, and we help supply information about both civil and criminal judgments regarding people in Canada. I do not recall, Senator Kime, any official type Canadian law that dealt with that. I do recall a number of situations of sort of cross-border, hey, we have a judgment about this that covers this in this area, whether it's a debt issue, a bail, or probation issue, whether it's a family issue or things like that. And I know there is a cross-border law on families, so maybe that's not a good one to talk about. But
excuse me for just a moment, Justice Alexander. I want to give Caitlin Wolf a chance to respond if she has any more detailed information in response to Senator Kime's question.
Thanks, Chair Carney. Yeah, so as I mentioned, we did draft our Registration Act piece in conjunction with the Uniform Law Conference of Canada. They actually have a very similarly worded Uniform Law Conference of Canada Uniform Act that pertains to these judgments. They have, something similar to our Recognition Act in place, and they also have enacted in a few provinces a similar registration procedure to what we have here in the second half of the bill. So that's why when I was trying to address uniformity and sort of these compromises and us harmonizing with Canada, that's what I was referring to. Some of the products coming out of the Canadian Uniform Law Commission.
Thank you so much for all those answers. I appreciate it.
Thank you for the questions. I see that Paul Chaikin, your hand is up. I didn't know if you wanted to offer an answer.
Just to remind the committee that we had testimony initially from the Maine State Bar Association Consumer and Financial Institution section, which is the committee of the Bar Association that includes these active practitioners in this area. From my own experience with the limited number of times that the MSBA comes before the Judiciary Committee, I thought it significant that that subcommittee of the Bar Association elected to advance this or support the advancement of this act.
Thank you for reminding us of that testimony. Committee members, are there any other questions for, okay, I see that there is a hand up. I was going to ask questions for Peggy or Caitlin Wolf initially, and then we'll start there. Representative Moriarty, did you have a question?
No question.
Okay. Committee members, are there any questions? Not seeing any. Did you want to make a motion, Representative?
Yes, I did, Madam Chair. I move ought to pass as amended, and the amendments that I have, I hope someone will follow along and track me, are, I think, 4 in number. First of all, on page 6, in section 8903, subparagraph 2, we delete the phrases "or denies" and "or denial." The second amendment is to include the shaded language at the bottom of page 7 in subsection J. The final 2 amendments are to include the
Representative Moriarty, I'm sorry, I'm just having a hard time following you. So you're referring to the non-uniform language in subparagraph J?
I thought Caitlin said that was fine. But
okay, let's check with that. Caitlin, could you, and I'm sorry to interrupt you, Representative Moriarty, but I didn't want to get too far down the road.
I agree.
I appreciate it, Chair Carney. Yes, I appreciate the opportunity to, yes, I would like to confirm that subparagraph J, Justice Alexander's suggestion, I think would be very wise for the committee to adopt that language. I think it would result in cost savings. So yes, the ULC would have no issues with it, would support that change. Thanks.
Thank you. Okay, you may continue with your motion, Representative.
Okay, Madam Chair, the final 2 amendments are to section 8911 and 8912 to include the effective date of January 1, 2023.
Thank you very much for the motion. Committee members, is there a second? Seconded by Representative Sheehan. So we have a motion ought to pass as amended with a second. Is there any discussion of the motion? I am not seeing any hands raised. I would just like to briefly comment that I think recommending passage of this legislation as amended will be a great benefit to Mainers, and especially to Mainers who are engaged in business across borders in Canada. It provides a significant cost reduction in the process they have to follow and simplifies the process they have to follow to collect Canadian judgments. So I think it's a really helpful suggestion, and I appreciate the Uniform Law Commissioners bringing it forward to us. Any other discussion? It appears that the committee is getting ready for a vote, so I'm going to thank our guests and return you to the attendee part of the meeting before we vote?
Thank you, Madam Chair and committee members.
Okay, committee members, I think we're ready for a vote, and our clerk, Ms. Panett, has joined us. Go ahead, Ms. Panett.
Thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Kime. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 6 members voting in the affirmative, 3 members in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much. And for those who voted against the pending motion, could you please let us know what your report is?
Ought not to pass.
Good, everybody?
Thank you. And for members of the public who are listening or watching, those committee members who are absent have 48 hours to cast their vote on the motion. And so we'll have final vote count and a final committee report in a couple of days. And with that, we'll close the work session on LD 903. And we may change our order a little bit. I think that Representative Harnett is not able to join us for LD 233. And so we will move on to LD 1831, an act to improve the child and family court process. That is sponsored by Senator Baldacci. And I'm going to see if he's here so that we can bring him over. And I'm not seeing him. Peggy, would you like to go ahead with the bill analysis? Oh, he is here. I'll bring him over.
So this is LD 1831, an act to improve the child and family court process. And the bill does 3 main things. One, it requires the Chief Justice and the Chief Judge in the Superior Court, Supreme Court, the District Court, and also for the family law magistrates to establish annual training and education about domestic violence and child abuse, neglect, and maltreatment issues. So that's sections 1, 2, 3, 4, 5, and 8 of the bill. The section 6 of the bill increases the number of family law magistrates from 8, there are 8 right now, to 24 by August of 2024. And that section also changes the duties of a family law magistrate. Family law magistrates are not judges, but they are selected by the chief judge of the district court in consultation with the chief justice. They are governed by the Maine Code of Judicial Conduct, and the scope of their work is really supposed to be focused not just on family law, but they have to have something to do with establishing child support, because I think Julie Finn had said 66% of their funding comes from the federal government, and the federal government is providing that money to establish child support orders and to make sure that responsible parents are paying for their children. So that's how children are being supported. So you're going to have to be very careful to make sure that you don't stray too far from what the federal government is funding. And so in paragraph D on page 2 of the bill, it identifies all the authority that the family law magistrates have. And one of the things that this bill strikes out is, one of the things that the current law says is, although the family law magistrates can act on interim orders in divorce, legal separation, parentage, or parental rights, what they can't do right now is when those are contested, except they can, if it's contested child support, the family law magistrate can act in those matters. And so this bill would take out that exception for anything that's contested. Actually, if it's contested, if both parties consent to the family law magistrate making that decision, that is okay under current law. This would take that out. So even if it's contested, the family law magistrate would be able to enter an interim order, even if the parties didn't consent to be handled by the magistrate rather than a district court judge. And then the last thing that this adds is the involvement in child protection actions. So all pretrial and interim elements of child protection proceeding, including child protection proceedings that are brought under, that are part of a Title 19A. So 19A is where the family law is. Title 22 is child protection actions. And then Section 7 of the bill directs the state court administrator to provide necessary staff for 24 family law magistrates. Staff would be, I guess, identified as whatever is necessary to support the magistrates. I don't know if that covers court clerks or law clerks or marshals. And I think you'll probably hear a little more information from the judicial branch about that. So I don't know exactly what the restrictions are in using that federal money. I would be concerned that if you're expanding the roles of the family law magistrates pretty much beyond what's currently in law with regard to anything other than child support, that you get some kind of a read on whether the feds will continue supporting the family law magistrates. If you go too far, they might pull the funding altogether. And what is definitely clear is the federal government will not provide additional funding, even if you have more magistrates and even if they're still doing child support. There isn't, I don't believe there's a mechanism to draw down more money at this point. Does anybody have any questions? I know that you asked for a lot of information, and I think Julie Finn has put together information. I sent you memos and some other information. I'd be happy to share the screen, or Julie can share the screen when you get to that.
Thank you. Committee members, I think it would be helpful for us to hear from the judicial branch next, so that we can ask questions about the jurisdictional changes. I guess there are two major points here: the jurisdictional changes and then the number of magistrates. And I think she's probably in the best position to answer them and has done some good research for us. So I'm going to bring her over to the panel. And Senator Baldacci, I wanted to welcome you to the Judiciary Committee. We're happy that you could join us for this bill this morning. And
Madam Chair.
yeah, we'll probably have some questions for you after we hear from the judicial branch.
Right, and I might ask if I could make some comments after Ms. Finn, if that was okay with the chair.
Yes, that's a great idea. Thank you. And welcome, Julie Finn, to the back to the Judiciary Committee.
Good morning.
Thank you for the information you prepared for us today. And could you please comment for us on both the jurisdictional changes that are suggested in this legislation, and then also the number of magistrates?
Sure. And we, with the assistance of the Family Division here, put together a memo, which I know Peggy sent around last night, and I hope you've had a chance to review. I sent that also to Senator Baldacci last night. It was kind of late, but I hope you had a chance to review that as well. We really spent some time thinking about this and thinking what we could do. On the jurisdictional issue, I think we have some reservations about the child protection piece, just given that we have tried and frequently successfully implemented a one family, one judge process in those types of cases. As you know, those cases are very sensitive. There's a lot of people involved. There's counsel for both parents. There's always the GAL. They're difficult, complicated cases, certainly extremely difficult for the parties, and having a familiar judge, which, as I said, doesn't happen 100% of the time, but we really strive for that, has really been something we've found to be beneficial. And also the judge is fully up to speed, on the case. It's efficient also because they're familiar with the issues and the people involved. And I'd also like to direct you a little bit on that to the Attorney General's testimony. I don't recall him, whether he testified in person, but he submitted written testimony that gave a very detailed description of the child protection process, and I think raised somewhat similar concerns, and also went into some detail about the one child or one family, one judge policy. So that is something that we think what we're doing now works fairly well. And if a magistrate were to do some of the matters and then a judge would do others, that might be a bit of a disconnect. In terms of the contested interim orders, as Peggy made reference to, I think we have no problem with that piece of expanded jurisdiction. And then I think your second question, Senator Carney, was about the number. And we did do some analysis on that. We polled our current magistrates. We looked at their caseloads, the busier courts versus the less busy courts. Also, you always have to take into account geography in this big state, and office space and the like. And I think the committee had asked me to come back with a number of what we could accommodate within our existing physical spaces. And our analysis came to the conclusion that for family law magistrates, which would we have 8 judicial regions, so that would be 1 additional per 2 regions, that would be very, very helpful in addressing family law cases, addressing folks that are waiting to move their cases forward, and that number we certainly can accommodate with what we currently have. So I think that was your questions. I'm happy to answer more questions if you have them.
Thank you very much. And I just wanted to ask a clarifying question on the jurisdictional matters. And so if you're actually looking at the bill at section 6 of the bill, And are you able to do that?
Yes, I do have it open, and I do have section 6.
Thank you. And so for on page 1, line 32, which is just the number, the judicial branch's recommendation is that 4 additional family law magistrates would be very helpful.
Yes, that's correct.
And then changing over to page 2, which is the jurisdictional description, paragraph capital D2. Is it the judicial branch's position that amendment to the law that's proposed here should or should not be incorporated?
I'm just reading through the stricken words. I think that addresses the jurisdictional issue in the contested interim orders, which, yes, I think we're fine with keeping that the way it is.
Okay. And then the concern that you raised with paragraph, subparagraph 4C, would the judicial branch's position be that it would not be appropriate to add that language?
You know, I think that would be our preference at this point in time. It's obviously the committee's decision and that of the legislature, but that would be our recommendation, which is in line, I think, with what the Attorney General recommended.
The one family, one judge system.
Right.
Thank you. Okay. Thank you for answering those questions. Committee members, are there any other questions for Peggy or for Julie Finn? And I see a hand up. Representative Babbage, go ahead.
Thank you, Madam Chair. Ms. Finn, I just want to confirm on page 2, D2, what you just read there that was stricken, expanding family law magistrates' jurisdiction to not be limited to just the consent, when the consent of both parties, but when there's a contested motion, which would be a new responsibility, as opposed to that going before a judge. That is an acceptable change for the judicial branch?
Yes.
So there's no perceived disadvantage to either of the parties by going forward with that?
No.
Thank you.
You're welcome.
Thank you, Representative Babbage. And Senator Baldacci, my apologies. I neglected to call on you after Julie Finn spoke to the committee. So you have the virtual floor.
Thank you very much, Madam Chair and members of the judiciary and Ms. Finn. And I appreciate your time. So as I explained when we did the public hearing, and I am fine with the changes that the judiciary and the Attorney General's office wants in terms of child protective cases. I understand that they feel that that's in a completely different track, or the way, managed in a different way. I am, the changes that we are talking about in terms of non-DHHS family law cases is a positive change. I don't see how it would threaten any federal funding, because we're not stopping magistrates from doing any child support cases. They're going to continue to do child support. They will have some additional responsibilities, but they will still do the child support cases that they currently get funding for from the federal government. I think that the only concern I have is, I understand 4 is an improvement, but I think that, and the way I interpreted the judiciary's response was that 4 was what they could accommodate in existing resources. But I would urge the committee that there's going to be a number, half a magistrate per district is still going to, I think the testimony is clear that's been submitted in writing, including by the Coalition to End Domestic Violence and others, that we're talking thousands of cases. So I think that respectfully, I have to ask the judiciary to consider more than 4. I think adding 1 per region may be the way to go, which would be a total of 8. And phasing it in, perhaps having 4 and then doing another 4 in a year or 2 would be a way to do it. By doing it, just on a side note, in terms of fiscal conservatism, I think that the state is getting a better bang for the buck by doing this with magistrates instead of adding a bunch more judges, which will take even more money and even more time, whereas the magistrates can be deployed relatively quicker. And I think that the state of Maine gets a huge value from these family law magistrates. It was an experiment started 20 years ago or 25 years ago, and it has largely worked and helped the system. But the pandemic has exacerbated the problems, and I really think that more than 4 magistrates should be considered, but obviously I will be happy with any improvements that this committee sees fit to make. Thank you very much. And I'm happy to answer any questions.
Thank you. Representative Babbage, I know your hand is up, but I just wanted to ask if Julie Finn, if you could comment on or explain to us in a little bit more detail the concern about the federal funding when you have, could you please give us a little more information about that?
Sure. And I completely agree with what Senator Baldacci just said about that. Currently, 66% of the funding for our 8 magistrates comes from the federal government. The reason for that is because it's approximated, and this is after doing a study, it's more than an approximation. We actually did a detailed time study a couple of years ago to determine how much of their time was spent on child support. Because as Peggy mentioned to you, the federal government funding is for the child support and support enforcement matters. So after the time study, it was determined that about 66% of their time was spent on those matters, and that is where the federal funding comes from. Additional positions are not going to change the overall percentage of Maine family law cases and issues that involve child support. So any additional funding for 4 or whatever number you settle on, more magistrates would all need to come from the general fund. So that's important to realize that there would not be 66% of the new positions would not be funded federally because the overall number of cases, that's not going to change. So we certainly welcome new family law magistrates and the work that they would do, but the federal funding would not expand with the expansion of a number of magistrates. So, and I did give a little bit of a fiscal estimate in my memo that would all need to come from the general fund.
Thank you. That's helpful clarification. Representative Babbage, you had your hand up. Did you want to ask a question?
Thank you very much, Madam Chair. With your recommendation of 4 additional, and you talked about resources being available in accommodation, at least in space, would there be a general fund allocation with necessary with the addition of 4 family magistrates?
Yes, and when I'm talking about accommodating them, I'm talking about existing physical spaces and more of the all other category. Their salaries, of course, would all be new funding, and in that amount, those amounts are included in the fiscal note, as are the additional staffing, which Peggy also made reference to, which would be a clerk, marshal, the positions that really need to go along with a judicial officer.
Thank you, Madam Chair.
Thank you. Committee members, are there any additional questions for Peggy or the bill sponsor or for Julie Finn? Senator Keim, go ahead.
Thank you. My question's for Ms. Fan. You mentioned there would be other staff to go along with the magistrates. Can you give us an idea of how many that would be? Like, if you have 4 new family law magistrates, will they each need 1 extra position in addition to that? So we'd be hiring 8 people in total?
No, it includes 1 position, 1 family law magistrate, also includes 1 clerk and 1 marshal and 1/4 of a law clerk. So for 4 new positions, that would be 1 law clerk, or the 4 could share that 1 position. Obviously, you can't hire 1/4 of a person. So multiples of 4 makes sense in this regard. So that's the position count.
Okay, thank you so much.
You're welcome.
Any other questions, committee members? I'm not seeing any. Is there a motion? There further committee discussion? Senator Kime?
Yeah, this is a little bit outside, but just another topic that I'm concerned about. But for Ms. Finn, would you see these positions as being helpful it's going to alleviate overall the court's congestion and then hopefully move cases. Is there any way to sort of quantify what that impact would be on the backlog?
That's hard to answer. Currently, while there is certainly waiting times for matters and this is just family matters cases, the backlog is less of an issue there than it is in, say, criminal matters, for example. And certainly having additional magistrates would assist people in getting into their initial court. And when they initially come into court, they have a case management conference. They hopefully can resolve some issues. They can schedule a mediation. It starts things moving, and I think that would assist Maine people involved in family court, very much to get that process moving. What it would not do is get them a final contested hearing any faster, because those go to the district court judges, and they're the wait for the contested hearing wouldn't change. So it would certainly be helpful, and that is why we have supported this bill and have put some work into fiscal estimate and analysis in the memo. But it would certainly help in the family law docket, which is why we've supported it. It's hard to quantify that, though.
Mm-hmm. A couple of follow-ups, if I may.
Yes, you may.
So not for today, but in some point in the future, if you could get us the backlog in family court, just so we would have that information for sharing with our colleagues, that would be helpful. And and then I missed part of your conversation around having one judge be handling the case all the way through, and you have suggestions so that we would still keep that policy in Maine, where one judge would be handling the case all the way through. Is that right?
Right. That's a policy in child protection cases.
Mm-hmm.
And so we had some concerns about expanding the family law magistrate authority or jurisdiction into the child protection cases, because that would challenge the one family, one judge policy, because there'd be magistrate involved. Later on, there'd be a judge involved.
Right.
There'd be less continuity there.
Right. So then the reason I asked that is because then these family law magistrates would not then help move child protection cases along faster.
They would not be handling child protection cases. There are some pretty strict time limits in the statute on child protection matters that are, of course, followed.
Okay. All right. Thank you so much for all those answers.
Oh, you're welcome.
Thank you. Senator Baldacci, did you wish to speak to the committee?
Thank you, Madam Chair. I just want to indicate that currently that people not only are waiting many months for a judge, they're waiting many months just to get they won't be able to have an interim hearing because one parent tends to object because they want to drag it out. There are hundreds, if not thousands, of cases where this leads to an interminable period of people playing tug of war with their children. So while these are not DHHS cases, these are the thousands of other non-emergency cases that people go through all the time in divorces and parental rights, affect a much larger swath of the population than just the child protection cases. I think the child protection cases are on a separate track because of constitutional issues involving parental rights issues. These family law cases need to have some certainty or stability, and so that they're not a tug of war situation waiting around years for any kind of judicial decision. And that's primarily what this will help people going through these separation or custody issues with children so that there's some better certainty, there's some control, there's some accountability in the situation to force people to hopefully behave better with each other and with the children. So that's really what we're trying to do here, is to improve the responsiveness of the judicial system. Thank you.
Thank you, Senator Baldacci. And I just had a question for you because my heart breaks when I hear about the tug of war that you've referred to. And so if we were to, we might propose an amendment to this bill, particularly with regard to the number of magistrates. But if we were to retain the proposal that you make to strike language from paragraph D2, so that talks about the interim orders. If we agree with you and accept the removal of that language, does that help address the issue of avoiding the tug of war?
Well, very good question. And you are absolutely right. That by itself will be a huge assist to the existing magistrates. I agree. And so you are correct. It will be a huge assist and a change in those cases, and will help get cases resolved quicker. I would still urge the committee to increase at some level the number of existing magistrates as well. Yes. But you are correct. That was one of the key things, was to change that so that magistrates could come in and make interim decisions and avoid the parental tug of war that can go on when these cases get dragged out.
Thank you.
Thank you very much, Madam Chair. And I'll be quiet from now on.
The information you've provided has been very helpful, and as with the information from Julie Finn and also Peggy's analysis. So committee members, I'm not seeing any hands raised for a motion, but I'd like to make a suggestion as to how we move forward. I would suggest that we amend LD 1831 so that we reduce the number on page 1, line 32 from 24 to 4, which is the number of magistrates we know the courts system could have physical accommodations for.
Chair, I don't mean to interrupt.
Please don't interrupt.
They currently have 8 magistrates, so we don't want to reduce it to 4.
Oh, okay. Thank you. I appreciate that. So we would, I get it. Thank you. So let me rewind what I just said, so that we would change the number on line 32 to 12. Is that right, Senator Baldacci? Okay, got my math straight. Okay, so we would reduce the 24 to 12. And then we would omit the additional language on page 2, which is paragraph 4, capital C. And otherwise retain the language in the proposal. And the other changes that are made in LD 1831. So I'll put that out there for discussion and a potential motion. Representative Thorne, go ahead.
Thank you, Madam Chair. I just want to, I may not have the updated copy that changed the language on page 3, line 21. It also states staff for 24. Should that also be changed?
Good catch.
I was muted. Thank you. That's a really helpful suggestion. Yes, but that would be another change. Appreciate you pointing that out.
Thank you.
Any other discussion, committee members? Senator Khan?
I would like to have a corner caucus before the vote.
Okay. And I see that Representative Moriarty has his hand raised. Go ahead.
Madam Chair, I just wanted to clarify the Senator Baldacci's comments concerning paragraph D2 on page 2. I understood him to suggest that that be deleted, but I may have been wrong.
Yeah, and I think my brain is getting all wrapped up in deleted versus not deleted. So what I was suggesting is that in paragraph D2, we accept the recommendation made by the bill sponsor that the final 3.5 lines be stricken.
Okay, thank you.
So maintaining the bill as it was presented.
Yes.
Okay, great. Thank you. Anything else, committee members? We will take a corner caucus, but would there be a motion? Representative Harnett? Oh, Senator Senator Sanborn.
So moved.
Is there a second? Seconded by Representative Sheehan. And so we have a motion on the table. We've had some discussion. We are going to take a corner caucus, but is there any discussion before we head to the corner caucus? Representative Thorne?
Thank you, Madam Chair. The so moved motion, I just wanted to clarify, was an ought to pass as amended.
Yes.
In the way described by Senator Carney just prior to the motion.
And including Representative Thorne's catch of the changing.
Absolutely.
Great.
Yes.
So that's the amendment, the initial plus those.
Yes.
Okay. Thank you.
Thank you. Okay, we will take a brief corner caucus. Senator Keim, how much time would you like?
Just 5 minutes.
Okay, so we'll come back at 11:40, everyone. Thank you. Representatives Harnett and Babbage, just to let you know, your video is still on during the break. Hi, committee members. If you are able to return to the meeting and activate your videos, please do so. Thank you. Representative Harnett, we had to skip over 233. I know that you had a bill in another committee. Do you think, don't know if you're waiting to be called back to that committee or whether we could move on to 233 when we're done with this work session.
We can move on. My obligation in labor and housing has come to an end. Thank you.
Great. Thank you. Senator Keim, go ahead.
I was hoping before we voted that I could actually ask Julia Finn one more question, and that is about the training piece. I don't know if the courts were in favor of that increased training, and I did want to hear from her about that.
Thank you. Julie, go ahead.
I'm just taking a look at the specific language. We do, and the judges in particular, have training built into their schedules already. We have, I believe it's 3, possibly 4 administrative weeks every year. And those weeks are used, a lot of what is used during that time is judicial training. I think we feel a lot of this is already being done. There was actually a new requirement about domestic violence training that just passed last year, although that was training for GALs. We did not comment on that section. I think this is something we feel we would not have a problem complying with. And it would not require additional resources.
Okay. Thank you for that. That's helpful.
Thank you, Senator Keim, and thank you, Julie Finn. Committee members, any additional discussion before we move to a vote? I'm not seeing any hands up, and our committee clerk, Ms. Panett, has appeared. So, Supi, we are ready for the vote when you are ready.
Thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Thank you. Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. So the ought to pass as amended vote carries 8-3 with 3 absences. Again, those committee members have 48 hours to vote. And with that, we'll thank Senator Baldacci for bringing this matter forward and for speaking with the committee today. And also thank you to Julie Fitt.
Just want to thank the committee and the chair and all the members of the committee for a great discussion. Thank you.
And with that, we'll close the work session on.
Actually, can we just get the report of the people who voted no?
Thank you. I'm sorry.
Ought not to pass.
Is that okay? Thank you.
My apologies. Okay, and now we will close the work session on 1831 and open the work session, jumping back in our schedule to LD 233, which is an act to provide electronic access to confidential juror information.
So this bill, you've had, you heard it last year and you carried it over, hoping that there might be a way to address it. And you had a work session back in January, and the judicial branch agreed to look at some of the questions that were raised. And I think that I guess I'll leave it for, did I send an email? I sent an amendment around, didn't I? I will pull that up so you can look at it.
Yeah, thank you. You sent an amendment that I think will work, so is implementable, shall we say.
Okay, and where is it? There it is. Okay, would you like me to share that now? I don't really know what led up to the discussion of the amendment, so I'll be happy to share it, and if you want it shared right now.
Yeah, if you could share it, and then we'll let Representative Harnett describe what led to the amendment. Thank you.
Are you ready for me to proceed, or do we want to give people some time to digest the amendment, Madam Chair?
I think you can proceed. People will maybe, need a little time once you've explained how we got to this amendment.
Okay. Thank you, Madam Chair. Just by way of background, when I first introduced this bill last year, we were talking about 4 separate groups of people that are allowed to access confidential juror information, though limited to the courthouse, and those being attorneys, their agents, investigators, and pro se parties. We recently met with Amy Quinlan from the Judicial Department, who indicated that they thought they had a fix to this problem. There had been, and I'm not the technological guy, so anybody can correct me, but there had been a pilot program using Citrix, a Citrix program in York, that the judiciary decided they could extend statewide, that would allow at least one of those groups of individuals, those being licensed attorneys, to access that information electronically. They would be able to access that information, but not download it or copy it in any way. And the court was comfortable, and I'll defer to Julie if she has other views on this, that it was easier to regulate the conduct of attorneys accessing this information to make sure it was kept confidential, because they are officers of the court. So the amendment proposed by Peggy does 2 things, as I understand it. One, it eliminates the words "may at the discretion of the court" in terms of making this information available, and changes that to "must," so that it's a mandatory obligation. And that obligation applies to attorneys, their agents, investigators, and pro se parties. It then goes further and allows access to simply attorneys in terms of the electronic availability of those records. It does not go as far as the original bill that I had introduced, but I think it is a very good start for our practicing attorneys. And I think there's also a reality, and I don't know the figures, but while we do have a lot of pro se litigants, it's less typical for pro se litigants to be involved in a jury trial with jury selection. They will still have access to this information, but under this statute, it will be made available to them at the courthouse. And the same is true for investigators. I assume attorneys and their agents would be covered by attorneys admitted to the bar. So I believe the Judicial Department is comfortable with this language, and I am. So I would ask for, I don't know if Amy is here, Ms. Quinlan, or if Julie can respond to their view of the amendment that Peggy just posted.
Thank you very much, Representative Parnett. And let me see if Amy Quinlan, on behalf of the Judicial Department, is here. And so I'm going to bring her over to the panel so that we can hear from her as well.
I'm going to stop sharing, but I can pull it up as soon as you want.
Thank you. And we are rejoined by Julie Finn and joined by Amy Quinlan. And first, thank you for following up on our request that you look into this. And I think you've had a chance to look at the amendment. Is that implementable from your perspective?
Senator Carney and Representative Harnett and members of the committee, yes, we do think that this is implementable, but there are 3 points I just wanted to make clear. The first is, it is, while we can control through this technology the ability to download so that folks who are accessing it would have view-only capability so that they can't download it, what we can't prevent is someone using their cell phone to take screenshots. So it is not impossible for that to happen. I just wanted to make that clear. That is the reality of our electronic world, and there is not really any ability to protect against that. So we wanted to make that clear. The second relates to the fiscal impact of this. This is a much, much less costly option. We have already in our supplemental budget a request for this technology, among other things, because we are using it in a couple of regards, one of which is a pilot program in York for attorneys to be able to send in their filings through the Citrix ShareFile platform instead of having to go to the courthouse. And we intend to implement that statewide as a benefit to attorneys so that they can do that without having to make that trip. So it's already in our supplemental budget, but we absolutely need those funds to be able to extend this license. So when the cost of that is about $80,000, which is much less than the $675,000 that I quoted to you the last time. And again, it's in our supplemental budget. So whether it becomes a sort of a contingent fiscal note, if we get in the budget, that's great. We don't need to assess a note to this, but that may be sort of, figure out which happens. But I wanted to be clear about the cost. And then the only other thing with regard to this is, as we are all concentrating on remote ways of doing things, we don't want to lose sight of the fact that technology sometimes fails. So if there was a way to add language that would provide for a failure of technology, if we had to resort to paper and it had to be made available at the courthouse, That's the only other caveat that I would suggest as I was looking over the amendment this morning. We just wouldn't want to make it impossible. Somebody, whether it's our system or an attorney's system, they may prefer not to receive it electronically. So I just am questioning whether there could be some wiggle room there. But otherwise, we think we can implement this. We think we can implement it statewide. And we think we can do that by the first of this coming up year. So January 2023, just to allow us time to put processes in place and all of that. But this is a very doable solution, and we're happy to be able to come back with a solution that I think fits the needs of the legislation and something that we can accommodate.
Thank you very much. I see that there are going to be some questions for you. Senator Keim, go ahead.
Just a clarifying one first, Ms. Quinlan, that this would be this electronic access would be part of the overall system that you're implementing that's costing $80,000. So this doesn't need a fiscal note, but if the other fiscal note doesn't pass, then this cannot go forward. Is that what you're saying?
So this isn't part of our Odyssey system, if I understand your question. This is separate. This is technology that we've implemented actually with ARPA funding as part of the pandemic response. And we're using it to allow for document exchange in remote cases. And we're also have implemented over the last month a pilot program in New York, as I said, to allow for filings to be submitted to a share file platform. That's not the same as e-filing, but it's a way that attorneys can submit their filings without having to go to the courthouse. So we currently have a license for that product, the Citrix product. And again, we use the ARPA funds to do that, but to keep that going, the cost of that a license for another year is approximately $80,000. That is part of our supplemental budget request as it stands now, amongst other things. But if we were not to get that supplemental budget request, we would need to have the funding to be able to purchase the license for another year, and it would be a fiscal note. So whether we submit it as a contingent fiscal note, we don't obviously need it twice, but we do need the funding to be able to purchase the license for that period of time, and the cost is $80,000.
And so, that is how I understood it. My second question, I guess, for you would be this product license that you have now and the ability to have the filings electronically. Are pro se litigants able to access this system at all at this time?
The system is not set up for, it's really for attorneys. And the reason for that is they have to register through the process. So at present, it's for attorney filings and not beyond.
Okay, I will let other people ask their questions, then I'll come back. Thank you.
Representative Harnett.
Thank you, Madam Chair, and thank you, Ms. Quinlan, for being here today and for working on this with us. And I apologize, I keep putting a D in your name. Now that I see it typed out, I'll stop doing that, I hope. You raised three issues regarding the amendment, and I want to address two of those. The first was, and thank you for explaining what you can control and what you cannot control in terms of the information being available online. Although to some extent, that's an issue when people are looking at these documents in the courthouse. Although there is clerk supervision, the clerks are doing a lot of other things at that time. But what I wanted to point out, and it's in the summary, there are legal obligations regarding confidentiality. And if an attorney, as an officer of the court, violated those confidentiality provisions, he or she would suffer legal consequences, correct?
Correct.
Okay, so that gives that layer of protection, or an additional layer of protection.
An additional layer, correct.
And the third issue you raised was the reality that remote technology doesn't always work, which to me would, we've done a lot with remote participation in terms of public meetings, and we never added language that I'm familiar with, that what happens when that fails. It's more that we know that it could. Did you have specific language that you would want in the amendment to cover the judiciary for that possibility?
So I think something such as "if possible" could be added to the end of that sentence. There may be a more articulate way of putting that. But just to allow for the contingency, because if we weren't able to send it electronically, we would revert to the access at the courthouse under either scenario, if the electronic aspect wasn't possible. So we just want to make sure that there's an ability to do that. If for some reason technology fails us, then we need to go forward with paper.
Thank you, Madam Chair. Could I ask our analyst a question on that?
Yes, go ahead.
Is that language that you think you could craft without too much difficulty, Peggy?
Yeah, probably, if that's what you're looking for. Right. I mean, if possible is a very big exception, and I'm just wondering if there's a way we can kind of refine that. But still carry out that same idea. I mean, you're not just saying, well, we're not going to implement this system, so it's not possible. You're saying implement the system, and if you have a hiccup here or there, or a system crashes, you're not required to do it that way. You go back to the courthouse.
Right. So sort of to the extent technology is possible and feasible, or I would want it to be limited. I share your concern about the words "if possible."
Okay, I'm happy to work on that and work with Ms. Quinlan and bring something back to you.
Thank you.
I mean, I get the idea of what you're looking for.
Thank you.
Could I just, and I know that others have their hand raised, but I just wanted to raise an issue. When I think of a technology failure, I think of something that maybe would happen because a system went down, but then 15 minutes or an hour later or a day later, the system was functional again. And I'm just wondering if, I'm not seeing this legislative proposal as saying that something has to be instantly provided. And I'm wondering if the fact that there is kind of a range of time over which this could happen would mitigate concerns about a technology failure.
So it's hard to predict what might happen. It's just that from an administrative standpoint, as we are thinking about electronic solutions to our paper world, we also have to be cognizant of the fact that while the pandemic put an emphasis on the ability to do things remotely, there could be other scenarios where the technology is not possible, and we'll need to work around that, just as we have, in the reverse. So that's just, I don't have a specific concern. I think that this platform is pretty reliable. I would note that it would also rely on attorneys being able to have access to technology as well. So I just can't predict what that would look like. It's just making sure that since this information is confidential, except for as stated in the statute, that there was an ability to share it at the courthouse if we needed to have a workaround to this electronic function.
Okay, thank you. Representative Moriarty, I think you were next.
Thank you, Madam Chair. I have two questions. Ms. Quinlan, on the issue of technological failure, it seems to me that you have a fail-safe provision already in the bill, and that is that the paper copies must be made available to council. So if council has a system breakdown or whatever, they just necessarily have to refer to the old system and go drive to the courthouse and inspect the paper. I don't see the need to add more language.
I understand your position, Representative, and I share the reading of the language, but just the requirement that we shall, if there's, and you're right, there's no temporal piece to that. So I don't think we feel strongly about it. I just raise it after looking at the amendment today, just as a possibility, and not wanting to run afoul of our mandate to do so. I just raised that issue.
Okay. My second question deals with the York County pilot project. How long has that been up and running? Did you mention a few weeks?
A month.
A month, okay.
Representative Moriarty, I apologize for interrupting you, but if these questions are not germane to this particular legislation, just in light of the time, our workload, and the upcoming presentation at 1, I'd ask that you, if they're not germane to this particular bill, if you could hold off and pursue them another time.
Right, I do have what I think is a germane
question, go ahead.
now, and that is whether there have been any breaches of your system, which has been working for a month.
No, Representative, there've not been.
Okay, thank you.
Representative Babbage.
Thank you, Madam Chair. Hello, Ms. Quinlan again. Just 2 points or 2 questions. One would be the wording. I know it does say must be available to the attorneys. The names of prospective jurors contest must be. I don't know if must or shall changes meaning at all, but I don't know if Senator Carney was alluding to this, but I'm not sure that a language change is necessary to address what might be a technical error. I think what the language does do is obligate the judicial branch to provide the electronic access to attorneys when it's working. And if it's not working, then they have an obligation to fix it so that it can be working. If we change language, I worry that there is somehow discretion, and maybe even discretion as to repair, which I don't see. So that's just a comment that I have. The second thing I would ask Ms. Quinlan is, with the amendment, my understanding, I heard concerns about pro se parties having access to what might be sensitive information. Agents and investigators are also deleted in the amendment, to my understanding. When we talk about attorneys and their agents, I'm not sure exactly what that may mean, and I wondered if agents were subject to the Judicial Code of Ethics.
So to the Code of Ethics that would apply professional responsibility rules and regulations for attorneys, and I'm conceptualizing of that language possibly meaning paralegals or something like that. I would think that as their agents that would apply, but I don't know specifically. So I don't know to what extent, and depends on who the agent would be, but it very well may. But I don't know that I could offer a legal opinion on that without looking at it, but it is possible.
Thank you. And Madam Chair, the amendment I'm looking at is updated. That strikes all three agents, investigators, pro se. Is that correct?
Correct.
Thank you. Thank you, Madam Chair.
Senator Kime?
Thank you. One of the things that I'm finding very concerning is the idea that we're placing at a disadvantage pro se litigants. I think that our legal system should be providing equal access to folks, whether they have the money to hire a lawyer or whether they do not. And I'm wondering if the judicial branch had that discussion when they decided that the Citrix license would only provide a way for documents to be, handled electronically for a lawyer. And also if they've had any discussion about the idea that this bill further disadvantages pro se litigants by, in addition to what the courts have already made for a decision around the electronic exchange of information already.
So 2 points, Senator Kime. We, of course, share your concern with pro se litigants. We want to make sure that we're doing all we can to provide access to everyone. The pilot in York was done at the request of attorneys accessing the courts, and it is a pilot. It doesn't mean that it won't be extended, but as a pilot, that is the population that we're addressing at present. Does not mean that we won't extend it. With regard to this particular bill, I agree with you that it is hard to make a distinction, but when we're making these policy decisions, as you are making, it's important to remember the other piece to this. And I think we've testified about this a couple of times, and just how important the confidentiality is to jurors that are the key to our system. And we rely on them to come in and to perform their duties, and they do so willingly. But it is not infrequent that jurors raise the question to us about our protection of their information. And so we raise that as a fundamental concern here. And in the electronic world, there is a heightened pressure between access issues and confidentiality, and ultimately you all will make that decision about the best balance. But we come to you saying how important it is to us to make sure that jurors feel comfortable and understand that we are doing everything we can to protect their information. And hence, in this instance, we are suggesting that because of the nature of counsel, their ethical obligations, and their positions as officers of the court, that it is an easier function for them or for us to make sure that that confidentiality is protected. That would be the reason to distinguish. It is not meant to limit access for anyone, but sometimes you have to balance these pieces as you are trying to do here.
Mm-hmm. Yeah, I appreciate that, that, the court would feel it has better control over, an attorney. But I think the equal access issue has to have greater weight than it's having right now in this conversation about the idea that we are creating a disadvantage for one certain party. So, and again, like you said, anyone can take photos, I guess. So to the committee, I guess I would say that I'm suggesting that we would not be including the language of electronic access to the attorneys at this time, unless we feel like we could open it up to pro se litigants as well, which I'm not sure I feel comfortable with. I think the oversight of the clerk in the court, looking at, providing some sort of oversight that, someone's not just doing a screenshot or whatever, if it's electronic, but they can also grab their phone and take a picture if they're in the court. But if the clerk is there, I think there's some oversight. But I can't go along with language that just places someone, because of their economic status, that they don't have the equal access to our to the judicial system as someone who is a lawyer, when in fact in our law they're supposed to be able to represent themselves equally as a lawyer could. So I think to create a system where they're disadvantaged isn't right, even though I totally understand and agree with the ease of electronic access. But that's, I do like the idea of putting the word must in there. I think the courts must make this information available. But then to the further line where it says that we're not going to allow pro se litigants the same access, I can't support that. Thank you.
Committee members, I sense that we're moving to the committee discussion as opposed to asking questions of the representatives of the judicial branch. Does anybody have any final questions for representatives of the judicial branch? Representative Harnett, go ahead.
Actually, I'm prepared to make a motion. I don't have any further questions.
Still has nothing to do.
Okay, then let me do this. Let me thank Amy Quinlan and Julie Finn for being here today and answering our questions. And then Representative Babbage, did you want to ask a question? And if you could just do a quick question in light of the extensive discussion we've had.
Yeah, I appreciate that. Yes, it's for the judicial branch. And they mentioned that, I guess my question is, does Citrix disable the ability to print?
Yes,
It does.
Well, it disables the ability to download. It doesn't mean that you couldn't take a screenshot.
Well, that's my question. Is there prohibitions? I mean, we talked about the Judicial Code of Ethics as being important in all of this consideration. And I guess my question is there prohibition that is understood about the taking of screenshots? If attorneys are going to facilitate the process by taking screenshots and then taking notes as they wish, or use as they wish, or underline as they wish, after they print their screenshot, then I'm just asking, is it not appropriate for per se litigants to be able to take photos of the visits of the court once they see the information? I'm trying to equalize the access to information and get clarified the instructions to attorneys as they are looking at Citrix.
Yeah, it sounds like you don't necessarily have a question, but you're disputing the position that the judicial branch has taken.
No, I'm asking what the instruction is to attorneys, whether screenshots are appropriate or not. And therefore, if they are not addressed at all, or, but then perhaps, what would they think about screenshots being able to be taken, or, photos being able to be taken by pro ses at the court? That's the question I'm asking.
So the instruction that is given to all folks who are viewing the questionnaires is that they may not take pictures of the information. They can take notes, but not copy it otherwise.
Thank you. All set, Representative? Okay. All right. So once again, thank you, Julie Finn and Amy Quinlan. Send you back to the attendee part of the meeting.
Thank you.
And committee members, is there any discussion? Representative Babbage, your hand is up. Go ahead.
No, that's residual. Thank you.
Senator Sanborn.
Hey, Senator Carney. I just wanted to sort of, I think, voice why I'm okay with voting for this, although I appreciate what Senator Keim has raised as her concerns, which
Can
which
I,
think
I'm sorry to,
are
I'm sorry to
yeah.
interrupt, but we actually don't have a motion yet. I
Okay.
was about.
Do you want me to make one?
No, Representative Harnett wanted to, and then I'll call on you because he was about to make the motion when Representative Babbage had his question. So let me unwind a moment, let him make the motion, and then you can speak to the motion. Representative Harnett, go ahead.
Thank you, Madam Chair. My motion is ought to pass as amended without any further amendment regarding failure of the system. I've been persuaded by both Representative Moriarty and Representative Badge that is sort of built in. If there's an act of God or a technological failure, the court is still under the obligation to provide the information. So my motion is ought to pass as amended with exactly the language that was presented by our analyst.
Thank you. And Senator Sanborn, did you want to second that motion and speak to it?
Yeah. So as we heard from the representative from the judicial branch, the court is in a pilot phase of this, is rolling it out via Citrix to attorneys who are officers of the court and who are subject to the disciplinary measures, which are quite dramatic, of the court should they violate the confidentiality provisions that are part of their ethical obligation as officers of the court. Pro se litigants are bound by the same confidentiality directive, one could say, I suppose, but there would be no enforcement mechanism that's obvious to me other than perhaps contempt of court or something like that. But that would be very difficult, I think, to work through. What the text of the amendment has in front of us does not prohibit the court from giving electronic access to pro se litigants. It just doesn't require it. And I think that given where we are, and we often make incremental improvements in access to information, and I think given where we are and given where the court is in having piloted this for a month so far, that it makes a lot of sense to me to take this step. And I guess I would also just note that there are very, very few jury trials where there's a pro se litigant representing themselves in a jury trial where this would even come into play. I would, it's a vanishingly small number. I don't know if it's even one a year. Thanks.
Thank you, Senator Sanborn. Representative Harnett?
Thank you, Madam Chair, and I will be very brief. I'm cognizant of the time. I just want to make it clear, while I obviously support this motion, I made it and I introduced the bill. I am not insensitive to Senator Kimes' concerns about access to justice. I've worked on those issues for a good part of my career, so I'm very sensitive to those. And I recognize that there is a slightly lesser bundle of rights being provided to non-attorneys here. I don't think it places people at a serious disadvantage. And again, there's nothing that prevents the court as they move forward from providing this information to others. It simply requires it for licensed attorneys, and we've all heard the reasons why, what can happen to licensed attorneys if they violate their codes of professional responsibility and ethics. But I did not want to seem insensitive to Senator Kimes' concerns. Thank you.
Thank you, Representative. Is the committee ready for the vote? It appears that we are. Thank you, Ms. Panett. And so the motion is ought to pass as amended with the language that was screen shared to the committee by our analyst during the discussion of the bill. And Supi, I think we're ready when you are.
Thank you, Madam Chair. Representative Galgay-Reckitt. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Kime.
No.
Senator Kime votes no. Senator Sanborn.
Yes.
Senator Sanborn, votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
All right. Yes.
Thank you. Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 7 members voting in the affirmative, 3 in the negative, and 4 members are absent. That is the vote of the committee.
Thank you. And for those who voted against the motion, could you please let Peggy know your report?
Ought not to pass.
So I would have an ought to pass as amended, and it would be only that we keep the word must, and that the court must provide the juror forms must be made available. And yeah, and if there's only one pro se litigant a year, then it seems like a small number to have allowed the same access as lawyers. Thank you.
May I ask how Representative Poirier is voting?
I'm an ought not to pass. Thank you.
Thank you very much.
Representative Harnett, is your hand up anew? Okay.
Not anymore.
Thank you. Committee members, it is 12:30 almost. We do have a presentation at 1 o'clock. And no, is the presentation at a different time, Peggy?
Thought we at one point thought it set it for 2 o'clock.
It is at 2.
So yeah, I'm sorry, I have 2 calendars. One calendar says 1 o'clock and another one says 2 o'clock. I think we had planned it for 2 o'clock because we thought this might run late.
Okay. Thank you. So Soupy and Peggy and committee members, are we okay with finishing up our work sessions and then taking a break before our 2 o'clock presentation?
If it's 2, yeah.
Okay, great. Then we'll keep going. Representative Evangelos?
I just want to point out every public notice I've had on the deadly force panel says 1 o'clock. I haven't seen anything about 2 o'clock. Could somebody please document that?
Okay, we'll just take a moment to try to straighten this out, everyone.
Madam Chair, I'm looking at the schedule and I'm also seeing 1 o'clock, but if you'd like, I can certainly contact the people that would be coming to the deadly force panel and ask them to delay till 2.
Okay, I think that's reasonable, given the fact that some people have probably seen 1 and some people have probably seen 2. And it would be, I think, more respectful to make sure that we don't start it earlier than people are expecting. And in addition, we do have other work sessions that we need to get done today. Thank you for checking.
In all due respect, Madam Chair, I see no evidence that it was ever posted at 2 o'clock, and we have a lot of interested parties that are going to be listening in at 1 o'clock.
Okay, well, let's take a.
Can we just find some evidence that it was posted at 2 o'clock?
Yep, let's take a,
Madam Chair, point of order.
yes,
Can I just note that were we in session today in person in Augusta, we would very likely have to delay the start of any 1 o'clock hearing. It's normal course of business that our hearings start late. They just can never start early. And that's quite typical.
okay, let's take a 5-minute
May I
recess
interject?
until,
It would, ma'am,
excuse me, you're interrupting.
well, I want to
Let's
be
take a-
recognized, my hands
Excuse
up.
me, you're interrupting. Let's take a 5-minute recess.
May I be
and-
recognized?
And then we will reconvene once Peggy, Soupy, and I have had a chance to figure out if this has been advertised for 1 or 2. When we have more facts, we'll come back and have a committee discussion. Thank you, everyone. Hi, everyone. If you are at your computers, could you please return to the meeting? And to members of the public who are listening or watching, we're going to give our colleagues a couple of more minutes to return to the meeting. Okay, so we've done a little digging, and what we've learned is that in our planning meeting, we discussed changing the time to 2 o'clock. The presenters were notified that the presentation would be at 2 o'clock. However, there was something got lost in translation because, typically we do start our afternoon at 1. We intended to start this at 2. That's why we asked the presenters to be ready at 2. We don't think that it is appropriate to ask them to change the start time to 20 minutes from now when they were thinking it was going to be an hour and 20 minutes from now. Just doesn't give them enough time, I think, to get ready to appear. And I sincerely apologize to everybody. Sometimes these delays happen because of typos and other things. And sometimes, as Senator Sanborn pointed out, they happen because the legislative session runs over. And I sincerely apologize to anybody who's been inconvenienced or is upset by the fact that the presentation won't happen until 2 o'clock. But again, with just 20 minutes to spare, it didn't seem fair to the presenters to tell them that they had to be ready at 1 o'clock rather than at 2 o'clock. I hope you will all understand and forgive the mistake. Does anybody have any comments? I know Representative Evangelos, when we were trying to sort out what had happened, you wanted to say something. Would you like to say that, whatever that was now?
I'm all set. It was public noticed at 1 o'clock, that's all. So, but I accept your explanation. We'll do it at 2 o'clock.
Yeah, sometimes things just don't work out the way we're thinking that they will. So I appreciate that. Okay, everybody, we are going to charge ahead with our work today. I think we've finished the work session on LD 233. That is closed, and we'll open the work session on our next bill, which is LD 1900, an act to amend the laws governing name changes. And Peggy, if you could please give us a brief analysis, we'd appreciate that.
Thank you. So this is a change in the probate code where the name change statute is. And this is the process that any name change needs to follow, I believe. And last year you amended the law to provide a slightly different process for minors. This bill is directed mainly at adult name changes, but it does change the notice for minor name changes as well. So that's kind of the purpose of this bill, is to limit what kind of notice has to go out prior to a name change proceeding in probate court. And right now the law says for an adult, it's after due notice, and the bill changes that to after due notice to interested parties as required by law. The second section of the bill amends the minor name change language, and what it takes out is some language that says the court does not need to publish notice of the minor's name change unless the court orders that notice of the name change of the minor be published due to the specific circumstances of the case. So I think, so FLAC actually had come up with the language from last year, and FLAC supports this change, recognizing that the people who have to get notice of the proceeding, so before the name change happens, are listed in there, and they are any other parent, any guardian, any person or agency with legal custody of the minor, or the guardian ad litem of the minor. All those folks have to get notice in a minor's case. It's after the name change is made who is required to have notice, and that's what is being changed. And then section 3 is references the change made in 2 or 2A, that if the court limits notice, the court can also make the record of the name change confidential or not public. Representative Sheehan had an amendment at the public hearing that made some changes to section 1 of the bill. And she actually has another amendment that refines that I sent out this morning. And I don't know if you have that in front of you, and I'm happy to share that if when you get to that point. So if you have questions about the bill before you want to talk about the Representative Sheehan's amendment, I'm happy to talk about that.
I think let's go dive right into the amendment, please, Peggy. Thank you.
Okay, so the amendment, like I said, changes just one, and it takes out notice altogether about the proceeding. So it once the court gets the petition, the court may change the name of the person who is an adult, and the court may not require public notice before approving the name change. What happens in current, so that's the amendment. It totally takes out the requirement of notice, due notice as required by law. If there is notice that somebody wants to give, they're welcome to, but what the court cannot require is notice by publication. And the rest of the bill would be in place. And what you don't see is the current law does provide for background checks paid for at the cost of the petitioner. And it also gives the court the authority to not change the name if the court has reason to believe that the person is seeking the name change for purposes of defrauding another person or entity, or for purposes otherwise contrary to the public interest. So the discretion of the court to change name is retained. That's not changed. Here's the may right here is that stays, and it's just the notice that is being changed in this bill, in this amendment. Sorry.
Committee members, is everybody all set with the screen share? You had a chance to read it? I think we're all set. So let's begin with any questions that committee members have for Peggy. Representative Babbage, if you could go ahead and let's just do one question per committee member at this point so that we can complete our work sessions. You can go ahead, Representative Babbage.
Thank you. I just noticed actually that this the sentence added in this amendment dated yesterday it says the court may not require. That's just unusual to me. I mean, it's the may still rules, even though there's a negative in there. Or how does that?
So when you say may not, that means the court does not have authority. So in a sentence, you might say shall not, but the way we draft our statutes, may not means the court does not have any authority to do whatever follows. So this means the court does not have authority to require someone to do notice by publication or do any other public notice.
Thank you, Representative Moriarty.
Thank you, Madam Chair. Peggy, I have a question concerning the first sentence, and I have in my own mind a preferred version, but need to ask you whether or not what I will read to you is consistent with protocols in the revisor's office or elsewhere and would run afoul of something. The version of the sentence that I would suggest is, upon receipt of a petition filed by an adult under subsection 1, paragraph A, the court may change the name of that adult, period.
Yep, you could say that. That might even be a little bit clearer, but it also, you could also say that petitioner at the end.
Well, you could. I personally, I'd stick with the term adult.
Okay. There's something about that that feels a little more comfortable.
This is sort of a thumb in the wind thing. How does that, does this pass muster within? Yeah. Okay, thanks.
Committee members, any additional questions for Peggy? Representative Babbage, is your hand residual? And Representative Sheehan, would you like to address the committee?
Sure, thanks, Madam Chair. I just wanted to let the committee know that the amendment you just saw before you was the result of a conversation between Andrea Mancuso from the Maine Commission to End Domestic Violence and Quinn Gormley. I don't want to misrepresent the Maine Commission to End Domestic Violence's concerns, but they did want to make it clear in the language that petitioners could indeed provide notice by publication. And I see that Ms. Mancuso is in the attendee space. So if anyone has questions, she's available to answer them.
Thank you. Committee members, does anybody wish to ask Andrea Mancuso about the potential that one could give notice if one wanted to? Not seeing any concerns on that issue. Is there any committee discussion regarding the bill or a motion? Representative Babbage?
I would like to ask perhaps the sponsor if, regarding Ms. Mancuso's concern, if the court may not require public notice, if that word require actually addresses her concern.
Yeah, I think that was the intention in the amendment that you just saw. So Peggy drafted that amendment in response to Ms. Mancuso's concern, and she told me that she was satisfied with it.
Any other committee discussion? Is a committee member prepared to make a motion? Representative Harnett?
I move on to pass as amended.
And could you please let us know what your amendment is?
The draft that was presented today, and I may have missed a change that was suggested by Representative Moriarty because I had to get off and come back. I was having some connection issues. What was agreed to there?
I think there was a suggestion, but not an agreement. Would it be helpful to you, Representative Harnett, to hear Representative Moriarty recite his language?
It would be, thank you.
Okay, Representative Moriarty, could you please recite your language again?
Yes, glad to do it. It's only the first sentence, and it would read, upon receipt of a petition filed by an adult, under subsection 1, paragraph A, the court may change the name of that adult, period.
I'm comfortable with that language, so I would include that in my amendment. As amended.
Thank you, Representative Harnett. Representative Evangelos?
I'll second it.
Okay, thank you both. And now I'm turning again to the committee. Is there any discussion of the pending motion? Representative Thorne, go ahead.
Thank you, Madam Chair. By an adult is 18, I'm presuming? Is that what that insinuates?
Yes.
Thank you.
Thank you. Any other committee discussion? Not seeing any. The committee is ready for the vote. And thank you very much, Ms. Panett.
Thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim.
No.
Senator Keim votes no. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you. And for those who voted against the pending motion, could you please let us know what your report is?
Ought not to pass.
Everybody?
Thank you all. So the ought to pass as amended motion on LD 1900 passed 8-3 with 3 absences. And with that, we will close the work session on LD 1900. Thank you, everyone. We will move on to our next work session. This is on LD 1871, a resolve directing the Maine Human Rights Commission to extend its pilot program to investigate and report on incidents of harassment due to housing status, lack of employment, and other issues. And Peggy, I know that there is an amendment if you wanted to give us your analysis. Thank you.
Sure. Yeah, I mean, the title is just about what the bill does. There was a 2-year pilot project or a project created 2 years ago. It got a slow start because of the pandemic. The intent of this bill is to extend it for 2 years. And so maybe this is a good time to show the amendment. The bill kind of got the years mixed up. So the intent is to, the study started in 2020, so it will finish in 2024. There will be an interim report submitted instead of this year, next year, 2023, and then a final report would be issued in September of 2024. The 4 years started in June, so it would go June to June. That would give them time to wrap up and collect all the information and compile it and provide it to the legislature by September 15th. Any questions?
Representative Harnett?
Thank you very much, Madam Chair. Peggy, just to be crystal clear, this is simply really a technical correction to do what the bill set out to do originally, right? Add 2 years
Yes.
to it. Thank you.
Yes, I think that's a correct way of describing it.
Committee members, any additional questions for Peggy? And I did want to note that the bill sponsor is in another meeting and was not able to join us today. She's just is obligated to that other meeting. Representative Harnett, is your hand up anew?
It is up anew, Madam Chair. I'd like to make a motion ought to pass as amended on LD 1871.
Thank you. And Representative Newell?
Thank you, Madam Chair. I'll second.
Thank you. Can we have a motion and a second? Ought to pass as amended with the language that was screen shared. Is there any committee discussion? I am not seeing any, and our clerk is here to take the vote. Thank you very much, Ms. Panett.
And thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim.
No.
Senator Keim votes no. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Super, could I ask that you repeat the bill number and the motion?
I can repeat, if you want explanation, that's probably more in Peggy's line, but I'll give you LD 1871. The motion by Representative Harnett, seconded by Representative Newell, was ought to pass as amended.
Nay.
Thank you very much. Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Lippy. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you. And for those who voted against the pending motion, could you please let us know what your report is?
Ought not to pass.
Thank you very much. And
May
so
I ask a procedural question, Madam Chair?
yes, let me finish announcing the vote. And so the ought to pass as amended vote carries 8-3 with 3 absences who will have 48 hours to register their votes. Thank you all very much. And you can go ahead with your procedural question, Representative Thorne.
Is this what is considered partisan politics? When a Democrat-sponsored bill gets approved out of committee along party lines?
I'm not sure that that question is in order, Representative Thorne. I don't.
We're not discussing a bill, are we? Just politics in general? I can't ask a politics in general question.
I
just
don't think
wanna
it's
make
really
sure-
appropriate in a committee setting. I mean, we're here to talk about the bills that have been scheduled and publicly noticed for work sessions, and then to cast votes on them to decide
Okay.
the bills.
If you
have
can't
been
answer
noticed.
the question, I'm fine with that.
Yeah.
Thank you.
Thank you for understanding that it's just not part of our work session work. Thank you. Representative Knoll, did you also have a question? No, okay, great, thank you. Okay, and so we've concluded our work session on LD 1871, and we'll open our work session on our final bill of this morning, LD 1918, and that is an act to provide funding for guardians ad litem. This bill was presented by Representative Craven, and I'm not sure she's able to join us. I don't see her in the attendee space. But Peggy, if you could please, it's a really simple bill, but if you could give us the bill analysis, we'd appreciate it.
Absolutely, I'd be happy to. So this bill provides funding, $400,000 of funding in the second year of the biennium for guardian ad litem services in family matter cases. Right now, there is no state funding for guardians ad litem and family matter cases in the district court, which is where those cases are usually litigated. And the state does pay for guardian ad litem services for child protective cases. But these are not child protective cases, they're family matters. If a guardian ad litem is appointed, it's paid for by the parties somehow, or there are some guardians ad litem that do pro bono work. But I'm not sure if they're expected to take one or more cases per year. Usually the guardian ad litem order identifies who pays or how the pay, first it establishes what the cost is, and it establishes which of the parties pay what amount of that cost. So this would be $400,000 of new appropriation that would go to the judicial branch to allow the appointment and compensation of guardians ad litem and family matter cases. You asked for some information from the judicial branch about guardians ad litem in general and the different types of cases in the different courts and what would the $400,000 cover. And Julie Finn and her crew have put together a couple of memos for you and some other information, and I'm sure they can walk you through that, and I'm happy to share whatever you need on the screen. And I see that Representative Craven is here as well.
Thank you very much. Thank you for letting me in. And I noticed how hard this committee is working. I always thought our committee was the hardest working, but now I noticed it's judiciary, so I concede.
Spread the word.
Having spent time in your committee, I think that your committee is incredibly hardworking, as are all of our legislative committees. Thank you for joining us, Representative Craven. And I think committee members, we will invite Julie Finn over to provide us the information that we requested of her. And Peggy, I have a feeling she may want you to screen share, but let's start by bringing Julie Finn in to the meeting. Welcome back.
Good afternoon.
Good afternoon. Thank you so much for gathering the information that the committee requested. Would you like Peggy to screen share the document you provided to us while you talk us through it?
Yeah, I think that would be a helpful way to proceed.
Okay, thank you.
I'm not sure which one you want first. Do you want the number of GALs per court location or the spreadsheet that has the 2-page spreadsheet? Or are you looking for that memo?
If you're asking me, I think the numbers kind of speak for themselves and don't necessarily require a lot of elaboration. So maybe just the memo, which sort of has our process for trying to determine what would be needed to fully fund the 19A guardians.
And that's the bill analysis, not the memo. Okay, I will find that and share that. I'm sorry. There it is. There it is. Okay. Is this what you were looking for, Julie?
Yes, yes, thank you. And so this, again, was done, there's a lot of information that was requested. And our family division, which is a wonderful group of very smart people, should get the credit for the information in here. But what the goal was to try to assess what the need is in this area. And we agree certainly with Representative Craven that there is a need, that there is no public source of funds for guardian ad litems in regular family matters cases presently. There is a rule, I think Peggy made reference to, that asks or requires guardians to do one case per year at an either pro bono or reduced fee basis. But that, I'm told that provision is not enforced. So it's difficult to know. I'm sure most, if not most of the GALs probably do that. And as Peggy also mentioned, I think there are some who do way more than just one per year. Some people are very generous with their time. So in order to try to estimate, and as I think I mentioned at the public hearing, we don't have a concrete way in terms of MIGIS and our data collection systems of knowing the exact number of cases that could benefit from the services of a GAL that did not have one appointed. So to go about trying to determine, to estimate it to the best of our ability, we again polled some of the family law magistrates and received, estimates from all of them. And they were asked two questions initially. And that was, what percentage of cases that you hear do you estimate would benefit from a GAL? And that includes the cases where a GAL was appointed and those in which one was not appointed due to lack of funding. And the average of their answers, and there are only 8 of them, as you well know from our discussion on the previous bill, was about 33%, or about a third of the cases. And then they were asked, of those cases, those that you estimated could benefit, what percentage involved a scenario where either neither party could afford a GAL and one was not appointed, or one was appointed, but it was done on a pro bono or low bono sort of reduced fee basis. And the answer to that question was, of those 33%, 46% did either not have a GAL or one was appointed at a lower or no fee. So Peggy, can you scroll a little bit?
Yeah, sorry.
Thank you. So this table 1 talks about the estimated number of cases that need a GAL and neither party can afford a GAL. So we found out the percentage by polling the magistrates. In this table, we're trying to determine a number based on those percentages. And so the total original filings and post-judgment motions to modify, enforce, and also contempt matters, these are cases involving children. And this would refer back to one of the other charts that I sent, which basically just had the number of these. There were 2 charts, the number of total original filings that involve children and the number of post-judgment motions that involve children. And the grand total is 6,021 statewide. And then with the estimated number that need a GAL, the original question, 33% of that is 1,987. And then 46% of those would equal 914 cases. And then scrolling down again a little bit, trying to determine the cost per case. Again, this is an average. And the average we have found is about 20 hours per case. At the original time of appointment, I think orders of appointment, generally there's a maximum of 20 hours put on any individual case. And if a GAL needs more time in order to complete his or her work, they have to go back to the judge and ask for just additional another subsequent order to increase the number of hours. So they're not allowed to go over 20 initially, even though some cases may need more than 20. And the $80 an hour is the fee that they get. So that equals $1,600 per case. We've put in a mileage portion because that is reimbursed to them. And that is a part of any case is driving. The GALs may drive between the parties and to schools and service providers and other places. So there is a small mileage number added as well. So the total estimated per case is $1,688. And then if you apply the number of cases and the funding per case, and Peggy, can you scroll again? Thank you. I do have this document, but it's open on a different screen and it's just harder for me to get there. So just doing the math, the total bottom line of what, from our best estimate, what the need is $1,542,811. I tried to explain the methodology. If anyone has any questions, please let me know. Like I said, we don't have a way to get absolute perfect numbers on this. So we talked to the experts, the family division, the family law magistrates, the people who work with these cases all the time to come up with our best estimates. And that's what I have provided.
See a couple of hands up. I think that the bill sponsor would like to speak to us. And then Representative Harnett and committee members, is everybody all set with the screen sharing or should we keep it up a little bit longer? I think everybody's all set with it. Thank you. Representative Craven, go ahead.
Thank you, Madam Chair. I just wanted to thank Julie very much for the information. It was great. The person that had asked me to file this bill is a mediator, and he has been years as a mediator, and pointed out how useful it was to the magistrates when an objective voice was offered, and that it made a much more stable placement for the child, and so wanted very much to thank Julie and the Office of the Courts for bringing the information, and thank you for allowing me to speak as well.
You're welcome, Representative, and we join in her thanks, Julie Finn. That was really helpful. Representative Harnett.
Thank you, Madam Chair. And this, I think, is following up on Representative Craven's observation. And I don't know if you can quantify it, but I assume magistrates will tell you that it helps to have a GAL involved in the case. And we focus almost exclusively on cost, but never look and try to quantify benefit. And when you were talking to the magistrates or when they were responding to you, did they articulate how the process is improved by the participation of a GAL, and in fact could result in some savings because the process runs more smoothly and is concluded in less amount of time and with less damage to young children?
Is that a question for me?
Yes, it was.
Okay, thank you. And yes, thank you very much for that question. I think you would find that the district court judges and the family law magistrates find that the services of a GAL in cases where children are involved is very, very helpful to them. And just to review, I mean, the GAL represents the children essentially. And the standard in these cases oftentimes is the best interest of the child. And if the GAL does not, or if there is no GAL assigned, then it's up to the judge or magistrate to assess what's in the best interest of a child. And let's say there's a contested hearing about that in a family, and that would involve possibly a great deal of testimonial evidence. they, in order to make that determination, they might have to have, whether it's people who work with the children. I mean, sometimes if the children are old enough, they themselves might have to testify, but the parties would have to basically meet their burden of proof in court on that issue of what is indeed in the best interest of the children. And they would have to submit evidence and probably take a lot of court time making their case in that regard. So the GAL would assess those same issues and do it outside of court, and can also take a deeper dive, obviously, because they're not limited by the four walls of the courtroom. They can visit both families, for example, in their homes. They can talk to other, possibly people at a school or healthcare professionals or others who work with the children about them. And so they just can get sometimes a better angle and more information about that family and about those children. And I think you will find that it would save court time to have GALs work in more cases. So thank you for that question.
Thank you very much for that answer. I appreciate it.
Committee members, any additional questions, either for Peggy or for Julie Finn? Representative Moriarty, go ahead.
Thank you, Madam Chair. Actually, I should have asked this question while Representative Craven was before us, but
she's still here.
Is she still here? The question simply is, would she consent to an amendment substituting the cost projections of the Judicial Department for the dollar figure shown in the original bill?
I'd be delighted with that.
Very good. Thank you.
Oops.
Done.
Committee members, any other well, let's start with questions. Any questions for Peggy or Julie Finn or Representative Craven? Representative Moriarty, your hand is up. Did you have a question or are you all set? No, okay. I'm not seeing any additional questions. Representative Babbage, go ahead.
Thank you, Madam Chair. Ms. Finn, this may be unfair, but I don't have it in front of me. Do we have an idea of the GAL allocation currently and the number of cases they deal with on an annual basis? In other words, I'm trying to compare what if we're addressing a big chunk of the concern which has been given to us. And thank you very much for soliciting the numbers that you did. That's very, very helpful. I'm just trying to get a look at how does that compare to the big picture and how much of a difference are we making here?
Well, that's hard to say. So currently, there are according to our polling of the magistrates, there are GALs assigned in about 33% of cases, which is about 2,000 cases. Now, those are private paid, most of them, although there may be some that are pro bono and some where the GAL takes a reduced rate. So the goal of the memo, or what we were trying to assess with the fiscal analysis in the memo that we prepared, was what would it cost to fund all cases where a GAL would be necessary. So I'm not sure if that answered your question.
Yeah, I think you're clarifying the data that you gave me too. These were not hypothetical needs. These were where GALs were used, but at private cost.
Right.
Thank you. Thank you. That helps me a great deal. Thank you.
Thank you both. Any other questions, committee members? Not seeing any questions. Is there a motion? Representative Moriarty, is that why your hand is up?
Yes.
Okay, go ahead.
Madam Chair, I move to pass as amended. The amendment would substitute the figure of $1,540,000 for the figure of $400,000 as shown on the original bill.
Thank you for the motion. Is there a second? Seconded by Representative Harnett. And before we move into the discussion on the motion, I would like to express thanks to Julie Finn for that analysis of information that was very helpful to the committee.
You're most welcome. And as I said, I really can't take credit. It was the wonderful folks that I work with that did all the work.
Can you express our thanks to them as well?
I will.
Thank you. And committee members, is there any discussion on the pending motion? Representative Babbage, your hand is up. Is that residual? Okay. Representative Newell, go ahead.
Just a quick question in my notes. Am I to understand correctly that there was no prior state funding allocated?
That's correct.
Thank you.
Any further discussion, committee members? Not seeing any. I would just note that I have served as a pro bono guardian ad litem and had firsthand experience as to how hard guardian ad litems work. My colleagues who were doing the same volunteer work worked quite hard, and also how valuable it is to the court system to have that guardian ad litem work and report available in determining the best interests of the child. It really is incredibly important. And I'm pleased to be supporting the motion. All right, any other discussion? The committee is ready for the vote, and thank you very much, Ms. Panett.
Thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Keim. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
I will be voting nay on this one.
Thank you, Representative Thorne. Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim. Representative Hagan. Representative Libby. Excuse me, I should have repeated. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 8 members voting in the affirmative, 2 in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much. And for those who voted against the motion, could you please tell us what your report is?
I think we'll go ought not to pass on this one, Madam Chair.
Okay, thank you.
You're welcome.
And so the vote of the committee is 8 ought to pass as amended, 2 ought not to pass, and 4 absent members who will have an opportunity to vote over the next 2 days. Representative Craven, thank you so much for presenting this legislation to the committee today.
Thank you. Thank you so much. I appreciate it.
And so committee members, we will close the work session on LD 1918, and that completes the work sessions that we had noticed for today. And we do have our next committee topic is the review, and I want to make sure that I get the name of the panel correct. But here we go. So committee members, we will hear from the Deadly Force Review Panel. Their second annual report will be presented at 2 o'clock. Members of the public might be in attendance We had some confusion. We noticed this for 1 and 2, but the presenters were told 2. So we are going to start that presentation at 2, and the committee will be on in recess until 2 p.m. Thank you, everyone.
You get the worm, Peggy.
I realized I had actually left the meeting, so I had to sign back in.
Oh, and that took what, 15 seconds, right?
At least now I have to change my name and get the committee clerk to change to a co-host.
I have to go in and out all the time. It's kind of a pain.
Yeah.
Oh boy, we got another snowstorm.
That's what I see. I love
to-
snow.
I do too, but I want to go to Nan's service on Friday.
Oh,
And the older I get, the less cool I am about driving in the snow. I'm
Yep.
like, and walking in the snow too. It's like
yeah,
I've reverted to a toddler. Remember when your kids were small, you see the world 6 inches at a time
yeah,
with their little steps. That's
Yeah.
what it's like walking with me when it's icy out.
yeah. No, I gotcha. Yeah, my son is supposed to be driving up from Virginia on Friday.
Well, maybe he'll be behind it.
Well, I hope so. I mean, I'm a little bit worried that the storm warning is through 1 a.m. on Saturday.
Oh, well, that's not good.
Yeah.
Okay. All right. What time are we at? 1:58. Time to relax for 2 minutes.
Plenty of time.
All right. See you soon.
All right, thanks.
Hi, Erin.
Hello.
I saw your video with Henry the other day online.
Oh yeah.
Nice. You guys were so natural. It was-
I know. I don't know why I haven't gotten more work in acting.
yeah, he was so lifelike. It was,
Oh, Henry
you know,
is
never
really awesome.
you never know who's going to see you on Facebook, and all of a sudden, this Phil Follies are calling, and
It's really true.
So you heard about Representative Harnett's steps towards stardom, right? Are we not talking about that?
which one?
Do you mean his Santa?
Yes, exactly.
It's going to be my seasonal career.
Yes, he got to play Santa for a PSA, right?
I did a PSA for the Department of for the governor, and did a couple of appearances in Maine and an appearance at a hotel in New Jersey.
Wow.
Yeah. And I made this much money.
But the
Tom
seeds
makes
are planted.
Tom makes an excellent Santa.
I can see that.
I've got some of the accessories that go with the job. We'll just leave it at that.
I'm sure you're talking about a lot of toys.
Must be. Somebody just warned me
This
that
is
we're
reindeer farm, Chris. Haven't you heard he has reindeer? That's what we were talking about.
somebody warned me we were live, and I said, we're human. We can talk, like we used to talk around the horseshoe. This is what people do.
And now it's recorded for posterity.
No, and if somebody really wants to go watch it, have at it.
Hey, anybody ever been through one of these before?
Yes. I don't recall this particular panel.
Is this a listen?
Well, Ann will explain, Senator Carney will explain it, but it's a listen. We can question, but not a.
And I did send the report when we received it, but I've also posted it under Judiciary Committee reports, and I will be happy to send it to you again, if that's an easier way to get it in your hands. I'm going to do that. And also the law library has a way that anybody can access this, and also their individual incident reports.
Okay. Is there anything else on the agenda after this presentation? for today?
I have a couple of amendments that I'd like you to review before they get reported out, but we can do that in the morning.
Oh, because I was going to say no, but see, I didn't.
No, I mean, I think it might be more appropriate to do it in the morning.
I did see the notes about other bills TBA or amendment review TBA or FOA review TBA. So,
just in case.
all right.
Thank you. Do you want me to send you the report, Representative Warren?
If you're going to be sharing them tomorrow or in an email, that would be fine.
Oh, I mean the Deadly Force Review Panel report, or do you already have that?
Had that been emailed to us already?
Yes.
That one I have, yes.
Okay, great. And I did send the amendments this morning for review, but we can take them up tomorrow. That will at least give you 24 hours to look at them.
Okay.
Thank you.
Thank you.
Hi, everyone. Welcome back. We're about to get started with the Deadly Force Review Panel presentation. But I had a question, Peggy, for you. I think that we had invited some members of Criminal Justice and Public Safety. Is that correct?
Sorry. We let them know that this was happening, but I also went back and realized that one of my notices to them did say 1 o'clock. So I did correct that to the chairs while they were in session today, hoping they could pass that around. And I offered a registration link for anybody who wanted to join that way. I don't know if that means you pull them into as a panelist, but at least they'd be part of the Zoom.
Okay, great. We can ask them when they arrive. Whether committee members, do you mind if criminal justice members join the panel for this presentation if they're interested? Is that okay with everybody?
Not at all. There's nobody in the attendee room that I notice.
Okay. All right. And then Peggy, for the presentation, we're bringing over Vendine Vafiatis and Francine Stark. Is that right?
Yes, that is correct.
Okay, well, I will bring them over. Oh, I had to sign back in, so I've lost my magical powers.
Oh, you know what? I did too.
Oh, I love the power that I have.
So, and I see the Attorney General is here too. I don't know if he's prefacing this report or not.
Oh, wait a minute. We lost Ann. Hold on. I have really messed up Ann.
Did you just remove her?
Yeah, I did.
There she is.
Superpowers. Superpowers, and they're not working.
You completely disempowered.
I did make all of a sudden. No. See, what's happening is that people are coming on and the screens are moving, and so everything that I'm doing is moving. I had okay, hold on. I've got up there. You moved again. Okay, there you are, and I'm making you a co-host.
Thank you.
Very welcome.
Okay, so I'm going to try to move others in, and hopefully I won't have that same situation arise.
That should help. Anybody? You're all set.
Okay. Welcome, Francine Stark and Vendine Vafiatis and Attorney General Fry. We're pleased to have you before the committee this afternoon to present the Deadly Force Review Panel report. And to start us off, I would just like to thank you for being here. And also, I think because this is a little different from our work this morning, I'm going to ask committee members to introduce themselves again, and then we'll ask each of you three to introduce yourselves. And so Representative Babbage, can you please begin?
Absolutely, Madam Chair. Thank you very much, and good afternoon, everyone. My name is Christopher Babbage. I represent House District 8, which is 82% of the voters of Kennebunk.
Senator Keim?
Good afternoon, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is northern Oxford County, in two communities in Androscoggin.
And Representative Thorne?
Good morning. Thank you, or good afternoon, as it were. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103 in the towns of Carmel, Herman, and Etna up in Penobscot County.
And Representative Evangelos?
Good afternoon, everyone. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you. And I just want to acknowledge, Representative, that you introduced the legislation that created the Deadly Force Review Panel. Thought that we should let folks know that. Senator Keim, Senator Sanborn.
Good afternoon. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Representative Sheehan.
Thank you, Madam Chair, and welcome everyone. My name is Erin Sheehan, and I represent House District 12, which is part of Biddeford.
Representative Newell.
Thank you, Madam Chair. Good afternoon, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Representative Moriarty.
Hello to all. I am Steve Moriarty, representing the towns of Cumberland and part of Gray.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. And Co-Chair Harnett.
Thank you, Madam Chair. Hello to all. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
Thank you all. And now our guests, I'm going to leave it up to you to introduce yourselves.
Good afternoon, members of the Judiciary Committee. My name is Aaron Fry, and I have the privilege of serving as Maine's Attorney General.
Good afternoon, everyone. Senator Carney and Representative Harnett and other members of the committee. My name is Vendine Vassiadis, and I'm a citizen volunteer member of the panel.
Good afternoon, everyone. Senator Carney, Representative Harnett, and all the members of the committee. I'm Francine Garland Stark. I'm the Executive Director of the Maine Coalition to End Domestic Violence, and coming to you from the shores of Patten Bay here in Surrey, Maine today. And it's also been my privilege to be the co-chair of the Deadly Force Review Panel with my good colleague, Vendine. So I think what I'll do is sort of start off a little bit in talking about the report and then turn it over to Vendine for some more words. You know, it's really been a privilege to serve on the panel since its founding. I'm really grateful for the opportunity to talk with all of you about the panel's work today. I've been an advocate in Maine's efforts to intervene and prevent domestic abuse and violence in Maine for 36 years, and I serve on the Domestic Abuse Homicide Review Panel as well, and have recently been appointed to the Maine Criminal Justice Academy's Board of Trustees. This work matters a great deal to me and to the constituents that I work with. The annual report of the Deadly Force Review Panel includes recommendations based on the panel's review of 10 cases that are summarized in Addendum A of the report, which includes some basic data from these cases on page 6, as well as data from 25 cases randomly selected from use of deadly force cases that happened between 2010 and 2018. In summary, the individuals against whom law enforcement used deadly force were white males living in isolation in rural areas of Maine who were in acute crisis, in part due to untreated or currently unmanaged mental health disorders, often expressing suicidal intentions, nearly always using alcohol or non-prescription drugs at the time of the incident. All had criminal histories and all brandished or fired a weapon during the incident, with about half also threatening their domestic partner who was on the scene. In fact, in one of these cases, we reviewed the individual had shot and killed his wife, adult son, and neighbor prior to wounding a bystander and shooting at law enforcement officers. We've organized the recommendations in 5 sections that we'll go over briefly. There are recommendations regarding law enforcement's collaboration with mental health services, recommendations regarding the development of protocols and training for effective response to mutual aid incidents, including centralized communications. There are recommendations specific to the Board of Trustees of the Maine Criminal Justice Academy, recommendations regarding firearms and prohibited persons, and finally, a few recommendations to the Attorney General. I'll turn it over to Vendine, who's muted.
Sorry. Thank you, Francine. I too have been on this panel for the last couple of years since its inception, and I've appreciated the opportunity to serve with the other panel members. It's a very intense experience. We meet monthly and we're very active in between. We all review hundreds of pages of materials and review calls from 911, videos from body cams and police cams, and it's a significant amount of opportunity to prepare for these cases. I want to say how one of the things that I've appreciated is that the other panel members are so committed and engaged and active participation in this panel, and we benefit from everyone's expertise, and especially from Francine's leadership. Based on my experience, past experience as Chief Deputy Attorney General and a District Court Judge, I'm not surprised by the facts of these incidents. But what I have been struck by is the overwhelming magnitude of law enforcement and first responder resources that are dedicated to these incidents. It's a significant response when you have a citizen engaged in either with a gun, using a gun, threatening suicide, barricading themselves in a car or in a house, sometimes with a hostage or other people at risk. They're very, very significant incidences, and the response by law enforcement and first responders is of a great magnitude. And I have to say that being involved in and having access to the details of these cases has been a tremendous learning experience for me. Francine gave us a summary of the profile of these individuals, and in addition to the 10 cases, I did review 25 other cases from the last 10 years, and was struck by the fact that, you know, of these 25 cases, 17 of them were in rural areas, and 10 of them involved the Maine State Police. You know, 8 of these men, because they were men, were under the age of 30. And as Francine said, they had, you know, very troubled in their circumstances, and impaired by untreated mental health, the substance abuse or alcohol. And of those 25 cases, half of them involved a past or ongoing domestic abuse situation. And to the best of our information available, 5 of the individuals at least should not have possessed a firearm, in the sense that they were either under a court order or had prior criminal convictions that prohibited them from having a firearm. We are a unique panel. We are organized under the Attorney General's office, but we only report to you. We are a panel that reports to the Judiciary Committee. That is, you are our constituents, you are who we are responsible to report to and to make recommendations to. So I view us as a legislative panel, and a panel that is serving the legislature and reporting to the Judiciary Committee. Each case we prepare, which we file with you within 30 days after it's completed, includes significant observations and many recommendations. And And we know that you have them. And we will, one of the asks we will have is that you make them more widely available. The other thing I wanted to emphasize before we talk about specific recommendations is the panel does two things. The panel does not conduct a de novo review of the Attorney General's determination regarding the legal use of deadly force. That is not our responsibility. We do not have statutory authority to do that, nor are we equipped to undergo that. So we do not do that. And second, we review cases where things don't go well. We do not review cases when law enforcement intervenes and are successful in de-escalating a situation, saving people, keep them from committing suicide, and saving lives. And just one statistic, we don't have a lot of statistics on the cases that we don't review, but one statistic in 2020, for example, there were 122 requests for assistance for the state police tactical team. The team was only activated in half of those circumstances, and the use of deadly force occurred twice in those cases. So it just gives us a little perspective about, even when you involve the tactical team, when they are very, very serious cases, they only 2 of those cases involved use of deadly force. So with that, I'll turn it back over to Francine so we can talk about our specific recommendations.
Thank you, Vendine. As we were getting ready to write this annual report, we pulled up the 2 prior reports available to us. And one was by the Attorney General's Task Force to Review Deadly Force Incidents that was put out in 2019, as well as the 2008 report of the Ad Hoc Task Force that looked specifically at the use of deadly force by law enforcement officers against individuals suffering from mental illness. It is abundantly clear that the vast majority of cases involving the use of deadly force by law enforcement in Maine involve an individual in mental health crisis. And as Vendine was saying, our job is to look at the cases where things ended badly, not to really do an overall assessment of the kinds of responses that law enforcement is making to a variety of crises involving mental health, suicidal threats, or domestic violence. But these tragedies involving the use of deadly force occur in a context in which we observed a certain lack of proactive collaboration, especially in rural areas, between law enforcement and mental health and substance use disorder service providers. So the first of our recommendations is that law enforcement and local service providers be better connected and familiar with each other's work, that they have protocols in place to support this coordination and consultation as appropriate during future crises. Recognizing that many law enforcement agencies do not have the financial ability to hire mental health or substance use professionals, the panel recommends that law enforcement officers receive training and education locally on the existing services in their area and how to access mobile crisis workers when responding to calls where there is evidence a person is living with or exhibiting a mental health or substance use disorder. I will note that in some of these cases occur so quickly. It goes from 0 to all over so fast. But in some cases, there's time. Some cases, there are a couple of hours or longer in which some additional consultation is possible. Every case is unique. But to support the recommendations to law enforcement statewide regarding mental health in particular, the panel recommends that the Maine Criminal Justice Academy set minimum standards for a mandatory policy that addresses protocols and procedures for responding to mental health crisis situations. And this policy should include a requirement that law enforcement agencies assess available resources and develop those relationships that may assist in understanding an individual's mental health history and particular de-escalating techniques that may be effective in resolving a crisis. In addition, the panel makes other recommendations for the Maine Criminal Justice Academy to develop a few policies and protocols. to tactical teams to have written policies regarding the deployment of armored vehicles, especially when interacting with persons in mental health crisis, to identify a list of standardized equipment that a medical kit should include, as well as training for its use statewide, and to enhance standards for compliance with the statutorily required internal incident reviews following the use of deadly force actions. This would include the scope of the review, the time between an incident and its review, and the composition of the review team. Sometimes we found that there were several agencies involved, but the review only involved the agency that employed the person who used deadly force. And we felt that all agencies involved from the beginning to the end should be involved in the review, for example. And I would just like to add that Maine Criminal Justice Academy is really unique in the country in the scope of its work, and is uniquely positioned to provide leadership and statewide support for implementing many of these recommendations. However, it is woefully underfunded to do all that Maine citizens need it to do. And likewise, resources to support community-based services for people living with mental health, substance abuse, and domestic violence challenges, particularly in rural areas of our state, are critically important to prevent situations from escalating and involving the use of deadly force by law enforcement. And I'll turn it to Vendine for some more.
Yes, I just want to not get into the weeds, and I hope that you have questions. Is I just want to touch on two other things that are in the report. One is what we found in terms of communications at the scene of an incident. Many of these, as like 2/3 or 3/4 of the incidents end up in rural areas, and often if they're in rural areas and they don't happen in an instant, a number of law enforcement agencies are involved. Might have a sheriff's office, might have a local municipal office, might call the state police, and there are not coordinated and centralized communication or command and controls in those incidents. And often that's from necessity. I mean, we even had, one of the cases, we had someone who was receiving information on his cell phone from his brother-in-law at the fire station. And so that law enforcement officer had some pieces of information, and other law enforcement had information from two different dispatches. And this is a coordination a problem, and we recommend that they involved in a more clarified mutual aid. We also made a specific statutory, as you offered us the opportunity to, a specific statutory suggestion regarding firearms. And a number of these individuals should not lawfully have firearms. In the sense that they are prohibited by statute for possessing them under Title 15, Section 393. A couple of instances we found that individuals, friends, family, other members related to them gave them access to firearms. So we are suggesting a small change to that, to the statute, and adding a provision that a person who intentionally or knowingly transfers a firearm to an individual that they know is prohibited from having that firearm is a violation of a Class D crime. One of our private attorneys that's on the panel, and one of the former district attorneys on the panel, suggested that this would be a potential loophole to close. So what I would like to end with, and happy to answer any questions, is we try to make our reports only 5 pages long. And actually, the substance of our annual report is 5 pages long. And the reports that we send to you after an incident are around 5 pages long. And we try to focus consistently as a group of what are the most important things to highlight. We come to a conclusion of the facts that we feel comfortable with to share with you, and a set of recommendations and observations that are very carefully thought out and worded. There's a lot of people that have to agree to sign those reports, and we haven't had a dissent yet. So we are very careful in trying not to overwhelm you, or in trying to provide a fair and objective and helpful report. So I have a couple of asks of you. We have no independent authority or power to do anything about our recommendations. So we request that you have discussions with the Attorney General's office, the Department of Corrections, the mental health community regarding our suggestions and our recommendations. We feel it's especially important that the community mental health regional relationships and training and coordination and centralized regional communication among the law enforcement agencies. I mean, that is crucial. The recommendations that team outlined, we for the mental health area. And as the reports have been posted
Excuse me,
on the
Vendine, the reception is very poor, I believe. And I'm wondering if you may want to try to deactivate your video, and if you could take a couple of steps back. I think you were making your asks of us, and if you could just start there again. We heard a little bit, but it won't hurt for us to hear it twice. Oh, I wonder if we've completely lost her.
It appears we have. May I make a request, Madam Chair?
Yes.
I cannot find that report in my email, and I didn't know if Peggy or Soupy could perhaps resend that to me.
Yeah, we can get that to you for sure. ASAP. Thank you.
So I
Welcome.
moved. I'm sorry, I faded out on you. I've now moved, hoping that my stream will be stronger. So I got just two things. And in my asks of the panel were to summarize that I'm asked of the committee that the panel has no independent authority or power to implement any of our recommendations, and that we request that you have discussions with the Attorney General's office, the Department of Corrections, especially the Maine Criminal Justice Academy, and the mental health community, through the Department of Human Services and community mental health agencies, to take a look at our recommendations and to see what progress they might be able to make with them. And we really thank you. Peggy explained at the beginning of the meeting about the publishing our reports online, and we really thank you for giving them some the public a place to access them. So with that, Francine and I would be happy to take questions.
Thank you both so much. And also thank you to the Attorney General for being here. We're going to start, actually, we have a committee member, two committee members, well, a committee member and a member of the Criminal Justice Committee who have just joined us. And I'm going to give them a moment to introduce themselves. Representative Hagan, could you go ahead?
Challenging when
Hi, I'm
kids
Dave
can't name
Hagan,
their emotions, and
House
there will be
District
some students that
101,
will always struggle with
Camden,
that,
and
but
Newburgh.
there
Thank you.
is.
Thank you. And Representative Warren, welcome to the Judiciary Committee.
Thank you, Madam Chair. Good afternoon, everyone. I'm Charlotte Warren. I'm the House Chair of the Criminal Justice and Public Safety Committee, and I represent House District 84. Thank you for the invitation.
Thanks for joining us. Okay, and I see that there are several hands up, and I think what we'll do is take a couple of questions from each person, and then we'll rotate around and call on someone else and circle back if committee members have additional questions. And Representative Evangelos, why don't you begin, please?
Well, thank you, Madam Chair. And good afternoon, Francine and Vendian. Vendian, you may remember I worked with you in the State and Local Government Committee when you did a very nice and valid presentation about reforming the legislators' salaries. Sorry, I was the only one practically to vote for it.
I do remember that.
Yeah. I'm trying to keep in mind that you are civilian members, and most of my questions today are for the Attorney General. And Madam Chair, I have a lot of questions today. So I would like to complete this line of questioning with the civilians, and then I'll move out of the way and direct my questions to the Attorney General after we hear other people, if that's okay.
I was muted. Thank you. That's a fine suggestion.
Okay. So to the civilian members that are on the panel, the evidence that you receive to base your discussions, collaboration, and findings on, those are single sourced, correct?
We start with the complete file that has been gathered by the Attorney General's office, which is all original material. I mean, we get a summary from the investigator, but all the material that backs that up, we get all the individual investigative interviews of everyone at the scene, all the law enforcement officers, civilians at the scene, even whoever if somebody transported someone to the ambulance, we get to see all the original 911 videos, all of that. And then if we have additional questions, information that we want, we get other information from any other law enforcement agency or anyone else that we seek any information from. So we get all original data, and we can ask for information beyond the Attorney General's files, Representative Evangelos, and we have in specific cases.
Right. But the material, what I'm getting at is the material you're analyzing comes from the Attorney General's office primarily. You're not hearing from the families of the deceased or witnesses or anything like that. You're not hearing the other side of the story then.
We have never invited an individual that was shot by law enforcement and survived, and there were a couple. Most of them are deceased, but there were a couple. We have not invited them to come and testify before the panel. You're correct.
I wanted to share with you something that the director of the Rhode Island Roger Williams University School of Law Criminal Defense Clinic said. His name is Andy Horowitz. Panels such as Maine's that rely heavily on Attorney General's reports that fail to critically analyze police narratives, true accountability isn't possible. It's highly unlikely, and I think what it is telling you that the system is broken and the investigations are not sincere. A prosecutorial entity will tend to assume credibility on the part of a police officer and do the opposite with a civilian. So that's a serious concern that I have. You're aware that our score in Maine is 178-0, correct? They're all justified.
I do know that, sir. Yep.
Well, I see that as a huge problem. I wanted to move on to the report. On page 10, and this is in reference to the Jason Gora shooting. And I'm going to have in-depth questions to the Attorney General on this. But it says here that the officers believed that Gora was holding a firearm and aiming it at them. They pretty much said that he had a shotgun. A shotgun is 4.5 feet long. Mr. Gora had a knife nearby. Believing Mr. Gora was levying a firearm at them, all 4 officers fired shots at Mr. Gora. He died at the scene. Shouldn't this report have indicated that the police officers made a mistake? He didn't have a gun.
I don't have that report in front of me, the full report. The information we received, we just provided summaries of the cases as were requested. There is a full report on that. You have in your file a full report on that particular case, and we did have the information in front of us that was not a firearm. That they determined after he was shot that it was not a firearm. We did have that information, and I believe it's in the longer summary in our full report.
Well, I think that's a pretty important discrepancy. I mean, in all honesty, hunters go out and they mistakenly think they're shooting a deer and they shoot a human being. They get charged with manslaughter. And for 4 police officers to cobble together this story that this guy was holding a shotgun and aiming at him, and there's no shotgun on the scene. I'm sorry, that's just, I find that highly disturbing. I want to go to page 6 of the report, just a small correction, but it says the panel has 15 members that are prescribed, 8 members represent law enforcement. But I went down the list, and the truth is 12 of the 16, one's ex officio, I guess, 12 of the 16 have law enforcement backgrounds. So they mentioned, the senator kindly mentioned that this was a bill that I sponsored. It got amended in committee. It's not what I wanted, but it's what I have to settle for because I was going to get nothing. I introduced a bill this session to decrease the law enforcement, increase civil liberties people, but it was defeated. I have a couple of other things. Can you help me with after the Gora case, a new disclaimer appeared at the bottom of the deadly force reports. It dealt with people on your panel and that there could be possible cases of conflict of interest. Do you know what the circumstances were as to why that paragraph was added after the Gora case?
I do, but I didn't remember that it was after the Gora case. I do remember what we had discussions from the very beginning of the panel about conflict of interest issues. And in my professional background, I've dealt with conflict of interest issues a lot. And so we had discussions of them. As I recall, when there was a conflict or someone perceived they might have a conflict of interest, that individual said that they did. They perceived they did. And the decision of the panel was to allow the individual to participate, but not to vote on any of, to participate in terms of listening. They had any thoughts, but not to vote, or not, well, I don't mean to vote, but not to make any determination about the observations or recommendations of the report. That happened a couple of times, and then we decided it would be useful to add language about conflict of interest so that we would disclose in the body of the report how we were handling conflict of interest. I'm sorry, I'm not saying that's not true. I don't remember when we did it. I know we didn't do it our first few cases, and it may have started after that case, at that particular case. But that's why we put it in there.
It happened immediately after the Gora case, because when I saw that John Chapman participated in the discussion of the Gora case, he was also for compensation legally representing several of the police officers. And he was a signatory to the Gora findings. And that is a very, very serious matter. It's actually a violation of the bar code. Says right here that you're not supposed to appear before any state bodies if you're representing people. So I raised the issue with the Attorney General. I have his email back to me right here. Nonetheless, the concern you raise is important, and that I understand on the face of this report, there is nothing to address whether the panel was aware of the relationship between Attorney Chapman and the officers involved. So I also have another issue I want to bring up regarding Mr. Chapman. Is the panel aware that Mr. Chapman contacted a media outlet and attempted to have a reporter removed from reporting on deadly force?
I am not aware of that, Representative Evangelist.
So I am asking the Deadly Force Review Panel to have a serious discussion as to whether Mr. Chapman should continue to serve on that panel. There's no way he should be violating a reporter's First Amendment rights to report. I got this right from the source when it happened. And I got it right from the Attorney General, who told me it shouldn't have happened. And he said to me, have you noticed we put a new disclosure on? And I said, yeah, you put a disclosure on because I complained. The last thing I wanted to talk to you about in the report, and I see in the report that we've delineated all the personal problems that these people had. And I know when Governor Mills, they tried to reform how we were handling this. I think probably this was during the investigation, but it specifically says the reputation and character of any person involved in an incident shouldn't be mentioned. And, you know, the way this report is written, none of these people deserve to die. I mean, I don't care if they had problems with drugs or what their background is. It's all irrelevant. It's irrelevant they had a criminal record. It's irrelevant that they had drug problems. It's all irrelevant. And, you know, I have to object to the way that was characterized. These people are human beings, 100% had criminal histories, 100% brandished or fired a weapon. That's not true. Laura didn't. You know, they have mental health issues. So I think we need to be a little more sensitive to that. And the rest of my questions are to the Attorney General.
Can I just respond to your last comment?
Sure.
Because I agree with you that none of these people deserve to die. I mean, nobody deserves to die. The reason we emphasized the mental health, substance abuse, and alcohol issues for these individuals is because it was striking that so many of them were under the influence of untreated mental health, substance abuses. We get the toxicology reports, substance abuses and alcohol in the situation where deadly force was used. And the tragedy, as you and I know, the tragedy is you're trying to deal rationally with an irrational human being. They're already upset. They're in a circumstance that they probably don't want to be, and it was really unfortunate that they got there. And then we bring rational people, law enforcement, other first responders there to interact with them. And it's very hard in those situations when people are so impaired to always have a successful resolution. I'm not saying that any one of them deserve to die, Representative Angelos. That is not my call. And I'm not saying that. And I agree with you with the sanctity of every individual life. And I agree with that. But it's overwhelming how impaired these individuals were when you were trying to bring a rational system of law enforcement telling them, put your weapon down, when they were so impaired. And that's the reason that we just highlighted those issues, because they're big issues for society and our communities if we're all going to be safe.
Thank you for that. And can I have your assurance that the issues I've raised regarding Attorney Chapman will be raised and taken care of?
I can assure you that we will discuss them. I can't make a promise about how they'll be dealt with, but I can assure you that I'll discuss them with Francine, and we'll figure out a way to have a conversation with the panel, with Attorney Chapman present.
Thank you.
You're welcome.
Representative Thorne, did you have questions?
Yes, thank you, Madam Chair. And I'll, Van Deen, it's easier to say that. I don't want to butcher your last name.
That's okay, Representative Thorne.
You had mentioned that the committee cannot direct or make recommendation to the Attorney General's office. Is that correct?
What I said is that we discuss a case after the Attorney General has issued a report on the legality of the use of deadly force in the incident. And what I was saying was that we do not have statutory authority to review that determination.
Or question it? Is that what you're saying? To say that it's correct or incorrect?
Correct. We do not have that authority.
Okay, thank you. If I may ask one more question, Madam Chair?
You may.
Thank you. We know that it was, what was the number, 179 since 179 deadly forces? It was used since going back how long? I heard Representative Evangelos mention there was 178 to 0 as far as justified use of deadly force? Does that
Yes,
sound right?
He said that. Yes, he did.
Okay. Do we track, or do you track, does anybody track the times, how many times police officers respond to a potential incident that deadly force was not used?
No.
In other words, I know it's hard to categorize possible deadly force may have been used, but what standoffs, for lack of a better term, that end peacefully without anybody being killed? Not peacefully perhaps, but that end in no one
No.
being shot. So
No, that's not a number that we have. And I think it's an important thing to keep in mind. You know, law enforcement is called to respond to crises
right. And
every day.
I'm not talking about, you know, a police officer shows up at a house because there's report of a deadly domestic abuse. I'm talking about when all hands called out to a standoff that ends peacefully. That's all.
Well, that's the number that we have in terms of the call out of the tactical team that
Mhm.
Vendine shared, and they put out an annual report. But we don't have those numbers for all of the agencies, because most of these kinds of crises are responded to by local agencies, small agencies in rural Maine. And that data is not available.
Okay, I was just wondering if there was a comparison between those that end peacefully and those that end in use of deadly force. Thank you. Thank you, Madam Chair.
You're welcome. And Representative Harnett, go ahead.
Thank you, Madam Chair. Get that hand down. Thank you, Ms. Stark, Ms. Vafiatis. It's nice to see you again, Vendine. Thank you for the work that you've done here. My questions deal exclusively with your recommendations, the recommendation regarding firearms and prohibited persons, where you suggested legislation to address those individuals who lawfully are not entitled to possess a firearm. And I thank you for that proposal. But you also mentioned that so many of the individuals that lost their lives were in crisis, with untreated mental illness, untreated substance abuse issues. Did you consider any statutory changes regarding having a process to get weapons out of the hands of people that we know could be unstable and dangerous, and as you said, could elevate a situation simply by having a firearm there? So I'm talking about people who have not been adjudicated that they cannot possess a firearm, but their circumstance in life might one question the safety of them possessing one. Does that make sense as a question?
You know, I think I'll let Vendine pick this up too. One of the things about the panel is that we have, you know, we're sort of volunteer participants. There's no paid staff to sort of take an idea and do research and draft. You know, we're doing this ourselves in our as our side gig to what we really do. And I think that is an important conversation. And part of, certainly for me in this report, and firearms and the intersection with, you know, there were a couple of cases that we reviewed where persons would have been prohibited because they had been subject to involuntary commitment. But when they were taken for evaluation because of a previous crisis, there weren't any beds available for involuntary commitment. And so they spent a period of time in an emergency room and were released. And I think one of the things that we point to in this report is that when we're looking at this sort of worst possible outcome, the tragedies of the use of deadly force, if we want to prevent this from happening, we have got to back up our point of view and recognize that when substance use treatment rehab beds are not available, and when involuntary commitment beds are not available, when qualified persons to intervene and prescribe and attend are not available, we have situations that have the potential to continue to escalate and culminate in these places. And it is so important for us to look critically at the actions of law enforcement, but for us to exclusively look at that moment and fail to consider this larger context is to really fail to inform good, comprehensive public policy with the potential to be preventive in nature and build the context of community that we want. And so I think that those deep conversations about how do we assess and appropriately help people who are not safe themselves to be in possessions of various kinds of weapons. How do we help make that real? How do we create a culture in which all of us who care about people who may be in crisis pay attention to whether or not they have firearms or other weapons with which they are most likely to cause harm to themselves? It's a big question, and I think it's one that you all need to talk about.
Thank you for that answer. May I have a follow-up, Chair Carney?
Yes.
Your answer, and I think rightfully so, focused on systems, establishing systems, mental health systems, more hospital beds, more professionals treating people. But did you look at using the law to try to prevent these tragedies from happening by not having weapons that can either kill somebody or lead themselves to be killed because of the mental health or whatever their physical or mental situation that they're in makes more likely than not?
We certainly discussed access to weapons. And Title 15, Section 393 outlines persons that are prohibited from having weapons unless they have a specialized permit under that section. And this was one area where we felt there was a gap. The comprehensive area of mental health is a very, very difficult one. And practically, we have reviewed a case in the past where an individual was prohibited from having a firearm because they had been a convicted felon. And once law enforcement got into that individual's home, they opened up a door, and on the wall were 69 weapons displayed on a wall. They weren't in a cabinet locked away, they weren't in a safe place locked away, and there were boxes of ammunition on the floor. So part of the intersect, Representative Harnett, is the law is only a good enough tool when it can be properly used and enforced. And in that case, that individual shouldn't have had those 69 weapons displayed on his wall with all that ammunition, but he did. And almost every case that we've dealt with, especially in rural parts of the state, most of the individuals, some of the individuals are already prohibited from having firearms. And as you know, they don't have one or two, they have dozens. So I'm trying to put a framework around individuals who have mental health versus, and you start to get in, well, should someone who has bipolar not have a gun? Should someone who's depressed not have a gun? I think it might be a useful conversation. I think it's a very difficult conversation to have. I'm not saying we avoided it because we talk about a lot of hard things. But it would be great if we could enforce the laws that we already have on the books. That would help a lot.
Thank you very much for your answers, and thank you for the work that you both do. Thank you, Chair Carney.
Representative Moriarty, go ahead.
Thank you, Madam Chair. My question goes to either Vendine or Francine. I want to understand the sequence of events that happens before a case comes to the panel. So assuming that an incident of the use of deadly force has occurred, is there initially an investigation on the part of the participating law enforcement agencies?
So the sequencing, Representative Moriarty, is the incident occurs. The Attorney General's office is notified. They send investigators to the scene. And then the Attorney General's office collects all the forensic data and interviews and everything and makes a determination. So then we have the Attorney General's report. In the interim, depending on the timing, separate from that, the law enforcement agencies that had officers who used deadly force at the scene do internal investigations on their own. They look at, they make their own determination of the facts, and they look at their internal policies, they look at the situations, they look at the equipment and the training of the officer, and they issue an internal report. What we have found, which is what comes out in our recommendations, which is probably what you're looking at, is that we find those internal reports to be somewhat cursory.
Yeah,
I'm not saying that the reports themselves, when they do them, when they do them, I'm not saying they don't do a good job, but the objective report that we receive looks very cursory, and we are suggesting to the Criminal Justice Academy, who was charged to come up with the framework for these reports, to look at making them more robust.
So the major investigatory activity is done by the Attorney General's office.
In terms of the legality of the use of force at the scene of the incident.
And only when that is done does the case come to the panel. Am I right?
Correct. That's correct, sir.
And is that automatic?
It is.
Okay, I understand now. Thank you.
You're welcome.
Representative Babbage and then Representative Thorne, I was wondering if you would let me ask a few questions before I call on you again, since you've had the opportunity to ask questions. Thank you, Representative.
Absolutely.
Thank you. Representative Babbage, go ahead with your questions.
Thank you, Madam Chair, and thank you, Ms. Stark, for this report, and Ms. Vafiadis, who I haven't seen in a long time. I thought citizen volunteer was modest, given the long resume that I'm aware of, at least, but I appreciate very much your contribution on this panel. One of you've emphasized mental health, and that is expected. I wanted to ask you a very general question, because as we navigate these waters in order to come up with a more effective response, I think there's sometimes, I don't know if I call it dissonance or, whoops, I've lost picture, but I hope you can hear me. There's a friction, I think sometimes within this discussion between whether that mental health expertise should be drawn from within law enforcement or externally. I wondered if you had observed that as either part of your panel's discussion, or if you had any, in-person testimony from members of the community.
We didn't have in-person testimony from members of the community, but I think that in looking at, what we know is that larger departments like Portland, for example, and can have on staff specialists who may be well-trained in responding to crises in ways that, you know, the Van Buren Police Department or the Fort Kent Police Department may never have. But the Fort Kent Police Department might have, and I believe they do have, a relationship with the Northern Maine Medical Center around mental health crisis intervention. So I think one of the challenges always to think about this in a full statewide way, and one of the reasons we emphasize in our report that where we see these incidents happen is primarily in isolated spaces in rural Maine, where, so if we're going to focus resource and coordination and protocols, that's the context we want to think in. And these are unlikely to be departments in which there are going to be lots of specialists and lots of this kind of resource. It's going to come from collaboration and coordination and that kind of work, which is one of the, you know, things that happens in rural Maine. But if you don't intend for it to happen, create the structure, develop and maintain those relationships, it's not going to work well. And so that's one of the reasons that many of our recommendations focus in that area. That helps.
Would it be fair to say that in your report, when you're talking about collaboration, you're talking about collaboration among law enforcement agencies, but also with mental health agencies, and that collaboration and training would be a two-pronged approach to this then?
Yes.
Thank you. Thanks again. I've lost picture, so.
But we can still see you, Representative.
Okay,
And
thanks.
hear you just fine. Thank you. And thanks again, Representative Thorne, for letting me ask some questions. I just wanted to take a little step back because I think that this is kind of an important perspective on the work of the panel and particularly the role of this report, is that you're not reviewing the Attorney General's assessment of any of these incidents of use of force for whether it was legal or illegal. You're really taking an overview and looking for opportunities to make changes. Is that right? And could you talk a little bit more about your role with respect to not any individual case, but really the kind of breadth of change that needs to come about?
You want to start that one off, Bendine? Or?
Sure. I think, well, we have a responsibility by the statute to look at each individual case as a separately. What you have asked us to do is within 30 days, what you've asked us to do is to take the Attorney General's, not to take the Attorney General's report, but yes, take the Attorney General's report and all the information that we can gather about a particular case and look at the circumstances of that particular incident. We're not trying to get out of our lane and deal with big policy issues. We're trying to have them as they bubble up from the individual incidents. And when we see patterns, then that's how you end up with getting what we feel warrants a recommendation. So personally, you know, I respect Representative Babbage saying that, you know, maybe more than a citizen perspective, but I try to bring a citizen perspective to this, frankly. And, you know, it's hard to not want to say bigger things than, but part of that would be based on my values, perhaps. And that's not what I'm bringing to this work. What I'm bringing to this work is a careful review of the circumstances around an incident that went poorly with some other very, very smart and talented people. And it is chilling sometimes when a situation, when we watch the video and read the investigators or listen to the investigation questioning of law enforcement officers and look at the videos and what happens in a circumstance of how fast law enforcement has to respond in some of these incidents. And so we try to look at why did this incident take place? What happened? What were the series of circumstances for the individual, for law enforcement, for the family, and for the community that brought them to this place? And then what happened in that moment? And then what did everyone do or think or reflect on it after? That is relatively narrow, but there's a lot packed in there. And I think we've only officially reviewed 10 cases. And that's why we went and looked at, I went and looked at another 25 just to sort of see, to kind of shore up with some of those trends appropriate. I don't think it's fair to make broad sweeping suggest if our experience does not back it up. So we have tried to stay in our lane and made recommendations that we feel would be, if implemented, would make things substantively better, but not get into broad policy discussions. That was a lot of words. I hope it sort of outlined kind of our thinking.
That was very helpful. And I think when you use the word, you're looking for patterns, I think that was more, I probably should have phrased my question in that way. With regard to your recommendations, and you made a lot of really powerful recommendations that I found really interesting. Is there one or a handful of them that you think are sort of would be the most impactful place for us to start with considering how we can respond to them? Like, where can we exert the most leverage as far as helping prevent uses of deadly force?
You want to go, Francine?
I think there's three layers of this. One is that I wish we would really implement the laws we have on the books regarding the possession of weapons and people legally prohibited from having them. I think that would be really helpful. Don't need new ones, need enforcement. And the second is that I think that we really should resource the Maine Criminal Justice Academy to do the job we've given it to do, because it is well able to create the kinds of framework for protocols and practices to affect all of law enforcement in our state. We ask a lot of them, and like so many things, don't resource the work that we need it to do, because it will affect all of the departments. I mean, it's quite extraordinary. That can happen quite quickly. We can have statewide impact. And really the third has to do with that integration of the work being done in the Office of Behavioral Health around the development of, sort of crisis response around mental health crises and substance use disorder crises, and how our statewide infrastructure to support people living in community with these struggles, how do we best ensure statewide access for all the people that need that, and where is the appropriate intersection with law enforcement and the criminal justice system as a whole in terms of how it manages folks who have come into that system with these kinds of issues and are living in community. People who commit domestic violence, people who go into the criminal justice system because of their personal behaviors, almost always come to live in community. And so how do we have all of these folks living in community safely has to do, again, with the responsibilities of all of us within that community. It's part of why that one particular suggestion has to do with, if you know somebody shouldn't have a weapon, you need not to give it to them. And there should be a penalty for that if you do. So I think that might have been more than three, but I can never pick one. It's just, you know, that's how I am. Vendine?
I agree with you, Francine, as I often do.
Thank you. That was really helpful information. I appreciate your responses. And Representative Thorne, you may go ahead with your question.
Thank you, Madam Chair. As a straight white man, I would like to defer my place in line to Representative Warren, where I've already asked questions.
Representative Warren, you have the virtual floor.
Way to keep it classy, Representative Thorne. Thank you. Thank you for the invitation to be here today. And thank you, Francine and Vendine, for all the work that you're doing. I appreciate it. My question specifically is around the intersection of communication and mental health and law enforcement. I know that the members of this committee have dealt with, for a lot of years, sort of trying to figure out a way to support law enforcement who really are called for everything, right? From the cat is in a tree to, you know, somebody is in a real mental health crisis. And we keep talking sort of about this lack of communication amongst law enforcement themselves, and how do we put up that infrastructure to support them, but also how do we properly resource other institutions that really should be called to deal with mental health crises or substance use disorder, that really we need our law enforcement officers doing what we've trained them to do, right? And they've got more than enough on their plate. And so I appreciate your recommendations about that, but I also noticed that you don't have specific language in the report. And I just wondered, is it the expectation that that's something that either the Criminal Justice Academy or the Department of Public Safety, because I saw they were both members or are both members of your panel, are they going to lead on those recommendations? Or is this something that Attorney General Fry is going to undertake? Who's going to lead on the fact that we keep seeing that these are issues, but I feel like we're not leading on these issues? We don't have anything from the Criminal Justice Academy saying they'd like, you know, additional resources or they need to do this training. In fact, they're opposed to a bill that we have in our committee that does plan to do sort of a strategic look at what their curriculum is and what kind of resource they have. When we've talked about mental health specialists, we've been opposed by the Department of Public Safety that that's really something that would be helpful. So my first question is, were your recommendations unanimous? And I think I heard that they were. And secondly, do you have an idea of who plans to lead on those proposals?
Well, we hope that you will ask them in and ask that very question. We, the panel, hope.
Okay.
They're only pieces of the whole, like I agree, and they're all there, but we don't ask them in the moment, will you do this? Because we don't have the authority to. Because in terms of examples about mental health, the complexities, as you know, Representative Warren, when you're out in a rural area, the first responder is the mental health person, right? I mean, if there's something unfolding with someone with a mental health problem, the person that arrives, which is often law enforcement or, you know, EMT or someone in rural areas, that's the first responder to deal with a mental health issue, however it presents itself. And often law enforcement or someone can manage it, but one of the things that we talked about was regular training in the communities with law enforcement and mental health folks and EMT folks. They do a lot of training, but they do a lot of training in silos. And I know they only have so much time, they don't have a lot of time to be there. They're trying to do their job. They don't have a lot of time to go spend days training, but those kinds of things, the community resources we have should be better coordinated, and they should be, and the time when you get a specialist to come in and deal with an issue that law enforcement has been called to is often either they're an employee of the law enforcement department or you're in an urban area and they know who to call. Those are like a third of the cases that we see. They might be, 50% of the cases or 75% of the cases, but the ones that we see are fewer urban cases. And so what we are encouraging is, we've worked hard at this as a group, and we have some consensus about need. And since we report to you, which is very unique, really, when you think about it, to have a panel that's created that reports just to a legislative committee. We're hoping that you might encourage them to come in and talk about these recommendations and what they're willing to work on. So we're happy as a panel to report to you and ask you for your help.
That's helpful. Thank you, Vendine.
I just wanted to, if it's all right, I wanted to just add a thing. I completely agree with what Vendine said. But I also, one of the things about serving on this panel is the privilege and burden of watching the movie. I have never seen so many images of people dying, really, people facing down literally the barrel of a gun. And some of these, and not all of these incidents are like a call to, we know there's someone in mental health crisis here. Sometimes it's somebody pulling somebody over because they were driving wrong in the middle of the night. And the officer pulls somebody over like they would, because it's not safe to have somebody weaving in traffic. So they pull them over. And seconds later, this is a deadly force incident. So I think one of the other important learnings for me in serving on this panel is the extraordinary variety of circumstances that law enforcement respond to, and the fact that in some situations there is no time. There is no time. There's no time to prepare. People are shooting at you and shooting at other people, and it is a moment. And there are other times when it's not like that. There's a little time to prepare. And so the fact is that while even for those cases where this happened in seconds and was not at all predictable in this moment, when we have the opportunity to look at more information about this person and the time just prior to this incident, what we learn is that these are also true things about their life experience. And so that is part of why we include that. And so it's like this larger context of people's lives is important to this moment, but it is not always a thing we can know about and mitigate the moment, if that makes sense.
Mm-hmm.
Sometimes it is, but I have dreams from all the things that I have reviewed to help people understand. And one of them is the response of a law enforcement officer taking the life of someone else. And I am sad that we live in a world where that is a thing that people are placed in a position to have to do.
Thank you, Francine.
Yeah, thank you. Representative Thorne, go ahead.
That's a tough follow-up there. I try to approach things from that point of view that everybody has a fight or flight instinct in them. And I know that that goes a long ways, and it's exacerbated by life situations, drugs, alcohol. And I know that hopefully our law enforcement is trained as such, but unfortunately, my questions go back about 4 or 5 people ago. So pardon me if I turn the page back to a conversation we had probably 45 minutes ago. But in the line in your report, it says 100% brandished or fired a weapon. And it seems like firearm and weapon are interchanged. And I don't know if that is 100% brandished a firearm or 100% brandished some type of weapon.
It's some type of weapon. The majority of the time it was a firearm, but we did have a couple of times when it was a knife.
Okay. And that was my point, is that it was kind of implied that it was a firearm, but didn't specify, because you can't fire a knife. I suppose you could throw it. And we had a gentleman up here in Orrington who held a knife to his own throat recently, and that one ended in a positive way. So, and I also want to address we addressed another bill about last year. It was similar in actions that had to do with confiscating weapons, whether that be muzzle loader, bow and arrow, firearm. It didn't specify knives, but you know, you can't take everybody's knives away, right? So the providing or furnishing, I think that would have to involve, you know, a phrase like knowingly or unknowingly. If my brother-in-law comes over to my house and takes a firearm without my knowledge, am I furnishing him with a knife if I unknowingly do it? Or am I somehow liable within my own home if it's not locked up or secure? So that kind of, and if he takes a knife and uses that, is that going to be same punishable as if he took a firearm? Those are just questions that I think of when I see the word weapon or versus firearm. So that's kind of a broad brush to say weapon. That could involve just about anything. So I'd like to see that narrowed down a little, separated between knives and other weapons and firearms, so that we don't get into everything means firearms when we say weapon. If that makes sense. Is it?
I understand what you're saying. And I think I understand what you're saying about differences of weapons. But the fundamental question you ask about someone takes a knife and then, you know, and I don't know about it and am I responsible for it, is there's an intentionality in when I wandered into my living room, I didn't bring the statute with me, but it says that you have to intentionally give it to the individual, knowing that they're prohibited from having it. So they can't just pick it up at your house and then you're responsible for Class B crime. You have to know it, intentionally do it, and you have to know that they're prohibited.
Okay, and I didn't see that language that said knowingly furnished, so.
Yeah, it's right there in the,
is it?
if we look, the language of the statute is very short.
Oh, in the statute.
It's after the draft there.
Okay, thank you.
Thank you, Representative Thorne, yes.
Representative Thorne, it was the proposed statute on page 5 of the report, and I did email that to you a little bit ago.
In there, and is it in blue or up above ABC?
Yeah, it's that is a proposed new piece of legislation, a proposed statute that is suggested in the report.
Okay. And we're just doing firearms? Is that it, as I understand it?
Yeah, that.
Just firearms, not bows, arrows, or crossbows this time?
I think that both Francine and Vendine are nodding their heads yes, that was their proposal.
Right. I have no idea how it'll get amended in committee though, how Representative Thorne, if it even gets introduced, even if it gets introduced.
I'm
Thank
flashing
you.
back to the bill that we worked last session that specified particular firearm, even though it didn't say ammunition. So, okay, thank you. Thank you, Madam Chair.
Thank you. And Representative Evangelos, I know that you said you had some questions for the Attorney General, and I think you're next, but I just want to check with Representative Moriarty and see if he still has questions for either Vendine Vafiatis or Francine Stark, just so that we can follow that order. Representative Moriarty, are your questions for the Attorney General, or well, can you let us know who your questions are for?
Actually, one question for you, Madam Chair.
Oh, okay.
Is this proposed legislation on page 5 pending now?
It is a suggestion that was made by the panel in the report, is my understanding.
Okay, so it has not been introduced.
Correct.
Okay, good, thanks.
Yep. Thank you for clarifying that. Any other questions for Vendine Vafiatis or Francine Stark, committee members? All right, any expressions of thanks for the work that they've done? I would like to express thanks for it obviously is very challenging and difficult work, and we know that it's a volunteer role as well. We appreciate all your thoughtfulness and hard work. Yeah. Representative Thorne, go ahead.
Yes, thank you. And I just wanted to say to Francine, I mean, have you talked to anybody about, because you just did mention that you have dreams and it's very disturbing, some of the video. And I wonder if that's something that you've thought about is some type of reaching out to somebody for your mental well-being, as far as some of the videos that you've seen that are disturbing?
You are kind. I thank you. I do have people that I talk with. And really, I have been doing this domestic violence work for a very long time and serving on the homicide review panel and now this panel. And I think it is one of the things that all members of panels have, is this sort of we study closely really disturbing things, and part of and we do have to find our support in order to move through that. But I think one of the things that's so important to inform change is to, in fact, have folks like us, and I invite others to volunteer for these kinds of service, to look really closely at the facts and the circumstances and the real human cost of the things around which we make policy.
Right.
If it doesn't actually get to our hearts somewhere, we don't tend to get the energy we need to make the kind of depth of change that we need to make. So I appreciate your concern, and thank you very much for that.
Wish you the best. Thank you.
Representative Evangelos, would you like to go ahead with your questions for the Attorney General?
Yes, thank you, Senator Carney. Most of my questions are going to be around referencing page 10 of the report today, but I have a couple of others as well. Good afternoon, Attorney General.
Good afternoon.
I have a report here detailing fatal police shootings per million residents in the past 6 years in New England. Quite frankly, it's shocking. Rhode Island had 4. This is per million population. Massachusetts had 6. We had 22. We had 4 times Massachusetts and 6 times Rhode Island. And have you given any thought regarding the decades of impunity without fear of being held accountable? The 178 to 0. 0 is an operative number here. All the police have to say is they felt threatened. They felt their lives were in danger. And there doesn't seem to be any critical analysis of that. You just accept their word and rule it justified. don't you feel that zero accountability is adding to the problem?
Thank you, Representative. I guess a couple of thoughts in response to your question. First, I view my job to take each case on its own, not in conjunction with other cases, in determining whether or not the evidence aligns with what the legislature has provided for when a law enforcement officer is permitted to use deadly force by statute. Just like we don't take different defendants' cases and pull in their facts to determine if that defendant committed a crime. When I'm looking at a case, I'm looking at the individual case and determining how the law applies. I do understand the concern that you raised, Representative, about how can this number be accurate, right? And I guess the thought that I'm going to offer to that is part of the benefit of the publicity that my office provides for what we look at and what we do, the deadly force review panels analysis and information that they provide, the availability of a public written determination by the law enforcement agencies who are required to make their own review. And then there's the opportunity for civil litigation that generates additional review. These are all different points at which my office, family members, members of the legislature can evaluate whether or not our laws and our policing are aligned with the values that were originally codified in statute. So I guess that's the summary here is I understand the number, I understand the concern. When I have a case before me, it would be completely inappropriate for me to do anything other than look at the evidence that is available in a particular case and apply the law to those facts. That's what I do. I'm transparent about that. That's public. And there are other points at which this review can be made to determine whether or not something may have been missed.
Thank you for that. I'm sure you're aware that several police departments have settled lawsuits and paid damages for cases that your department ruled justified.
Is that a question, Representative? Because there's a response to that.
Yeah, it's a response to what you said.
Right.
Well, you mentioned
Representative Evangelos,
here we go.
I'm sorry, it just seemed like that was a question and it might
Well, if he wants to
be
answer it, but I mean,
appropriate
he
to let
brought
the
up the
Attorney
civil,
General respond to
actions,
it.
and there have been damage settlements paid in cases where his department ruled him justified. I'm just making a point, but if he wants to respond to it, that's fine.
If I may respond, because I think I took that as a question. They're looking at two different things, right? So the extent to which my office is looking at whether or not there's a legal justification as provided by law, something passed by the legislature that requires me to take a look at whether or not the law enforcement officer underneath the statute was permitted to use deadly force. That's what my office looks at. A civil action is looking at whether or not the officer acted in some way that violated the rights of the individual. Two different legal analyses. Similarly, you also have you may also have some cases where the federal court or a state court did not find liability for an officer that I think families would still think deserve some attention by the AG's office on the question of whether or not there was the legal use of deadly force as provided by statute. So it isn't accurate to say that these are the same analyses. They provide the opportunity for a look at the case and the same evidence, but it's applying different law.
Thank you for that. I wanted to move on to the Jason Gore case. I've got, in the interest of full disclosure, I have the crime lab report in front of me and I have the autopsy. I have some questions for you. I noticed in your report on Jason Gore's death that you made no mention of the number of shots that were fired. Is there a reason for that?
There's no particular reason that comes to mind as to why I did or didn't do that.
Well, they fired at him 38 times, including one of the officers, had a automatic rifle fired at him 20 times. They shot him 8 times. I really struggle with the fact that we hold hunters accountable for shooting a human being, mistaking them for a deer. But these police officers, obviously to me, cobbled together a story that Gora was pointing a shotgun at him. A shotgun is 4.5 feet long, sir. And I noticed you put a picture of his knife. I mean, they shot him 8 times, and the next statement you make in the report is immediate medical aid was administered. I mean, what they needed was an undertaker, right? And the guy's dead. They shot him 8 times. So your failure to mention the number of shots is significant to me, because it's highly significant to the findings that are being made elsewhere across the country. Let me read this to you. September 2020, 4 Houston police officers fired after shooting man on the ground 21 times. Gora was on the ground. The police chief concluded that the barrage of shots was objectively unreasonable. So he concluded that a couple of the shots were reasonable, but 21 of the shots fired by the 4 officers were not, and he fired them. Why aren't we holding these police officers accountable in this state? I mean, Texas is a lot hardliner than we are on law enforcement. They've got a reputation, but they're able to get there, and we can't.
So if I understand the question, I'm not able to comment on the comparison between a case that I don't have before me. I don't have all the evidence in Houston and how it may compare or diverge from what the evidence was here in Maine before us in the Gora case. What has been made available publicly, what has been made available to the Deadly Force Review Panel, what I believe is going to be looked at in a federal civil case that's been brought by the family is you had a situation in which there was a high-speed chase after a prolonged period of trying to find Mr. Gora. Mr. Gora directed his vehicle for reasons unknown into a Mechanics Fall police cruiser, almost threatening the life really of the officer who was sitting in that cruiser, stationary. And then after apparently reaching around in the back of his vehicle, this is all in the dark, by the way. This is about, I can't remember exactly the time, but it was in the middle of the night. He starts to run away, does not listen to any responses to stop. And then you have to cobble together videos, but you watch Mr. Gora run across a parking lot, stop and turn. And that's when one officer dove to the ground, uttering a profanity because he thought he was about to get shot. And the officers who expressed that they believed that there was something in Mr. Gore's hand, which they believed at the time was a gun. It was described as a shockwave shotgun that has a bird's head grip. That is another type of shotgun, Representative, that's available to individuals out there. And they fired 4 different officers, ended up firing. So that was the evidence that was available to me. That was supported by video that was available to me. And I outlined all of that in what I provided publicly and reported on. So I'm not quite sure how else to describe. I can't respond to what happened in Houston. I don't know how those facts and that evidence compares to what we had before us here. As I'm sure folks in the committee might appreciate, I've spoken with you, Representative, about this case, and I've talked to you about this exact same process. I also appreciate that you don't accept my process and the conclusions that I reach based on my review of this evidence.
Thank you. You think shooting at a person 38 times is justified?
There's 4 different officers who are shooting at somebody in the dark, whom they believe has a firearm pointed at them. They're not counting the number of bullets. The way in which they're trained is to neutralize that threat to them. And so it's not simply, is it 38 bullets from one officer? To the extent that the video evidence and the contemporaneous excited utterances that were made by the law enforcement officers about what was going on, in terms of how they perceive the risk. In this case, the number of shots did not, for me, rise to the level making this unjustified as the statute provides. My analysis that governs my analysis.
But one of the officers said he thought it was a shock wave. The other three said it was a shotgun. It's 4.5 feet long, Attorney General. And if they're shooting somebody in the dark, they have a responsibility to know what they're shooting at. And they didn't. So the crime lab details 38 separate shots. I want to move over to the medical examiner's report. Can you tell me why the diagram of the body and the location of the shots was not included in that?
I do not have any response as to what you have, how you got it, and whether or not you received a complete. I don't have an answer for you on that.
I received it from the Gora family, and they told me, I asked them where was the body diagram, and they said it was never submitted to them. Can you see to it that they received that?
What I'm going to do is ask the medical examiner's office to forward what they were able to forward the family. That's the limit of what it is that I can do.
There's another segment of the medical examiner's report I found disturbing. These injuries will be described without regard to chronological sequence of severity of injury. The problem with that is that 4 or 5 of Gora's wounds were in the back, get shot in the back 4 to 5 times. It would be significant to know if the first shot was in the back. And I find it hard to believe they just glossed over that. Trajectory of the bullet, back to front. Trajectory of the bullet, back to front. Quite a few times. So, you know, Mr. Attorney General, I do want to review something with you. I have a report here.
Representative Angelos, you've gone through a couple of different reports with the Attorney General, and there were 2 other committee members who had questions.
I'd like to complete my line of questioning, or I can come back to it, but I'm not done.
Okay, let's let some other committee members have a turn, and then we'll come back to you. Representative Hagan, your hand was up, and are you no longer interested in asking a question? I'm just trying to make sure that every committee member has an opportunity to ask questions if they want.
Are you talking to me?
I am.
Okay.
Your hand was up, and I just didn't want you to lose your opportunity to ask a question.
Yes, I greatly appreciate that. Thank you, Madam Chair. My wife came in and she's talking on the phone with somebody. I was distracted, so I turned my sound off. So I apologize. I am a full-time teacher, as some of you know, and I had school today, and I also had to sit through a very long teachers meeting at the end, and I missed most of the early part of this. So I don't know who could answer my questions or my thoughts. So I would apologize in advance. I know that when I was listening to Ms. Stark and Vafiatis, they sounded very eloquent, and I appreciate all their words. And AG Fry, I appreciate your words well. I have been listening just very recently. But I was wondering if at any point people had applauded that 100% of the police involved shootings, while terribly tragic, as we all know, were fully reviewed and found to be fully justified. And it was not the problem of the police. I was also curious to know if, I know that funding for the police academy has dropped considerably over the years. And, you know, that certainly could weigh into these things. Also, use of a deadly weapon can be anything. Certainly automobile, baseball bat, knives, anything, including a firearm, you know, which could cause the death of another person, and police and civilians can do these kinds of things. I know that use of deadly force in Maine is rare. But most of the time, I have several trooper friends and sheriffs who have been awarded verbally or even publicly for not using deadly force when they've been able to avoid it. I know that I have actually been asked by the state police on one occasion to sit in on a deadly force panel way before I joined the Maine state legislature, and was astounded at the incredible professionality, intense details to which they looked into all of the details of the shooting, which included a 3-bit ring binder folder with about 500 or 600 pages worth of material, photos, video, interviews. I've never seen anything so thorough in my life. And it was impressive. And all of the reports that we receive of deadly force here or there remind me of that experience that I had. And I was hoping that somebody in these meetings, when I wasn't here, I'm guessing they did, of course, lauded the police for all of their really hard work and good work, as well as the attorneys involved, AG Fry and his staff and whatnot, for their thoroughness in going through these things to make sure that justice is properly served. I don't know where my answers would come. I don't know who, and I apologize for my lack of being able to be here, but that's all I have. Thank you.
Okay, I was struggling to identify what your question was. Can you succinctly state it, or are you all set?
Well, I don't really have a question, but I'm hearing a lot of negativity toward law enforcement, and I'm hearing that they're reckless and irresponsible. And that is completely not my experience. It's not what I've been reading. I have served on this panel before. I have a lot of law enforcement friends, and quite frankly, I think that of course, when you add humans to any scenario, there are going to be difficulties and problems. But I'm hearing a lot of negativity in a way that does not reflect the last 30 years of my experience. And I have experience in these areas. So I guess it's less of a kind of a question as to, has this been a very negative meeting, or have the sides that I've addressed been discussed?
I think we had a very intense and really informative discussion of the information that's in the report of the panel. And I would encourage you and anybody else who's just tuned in on YouTube to go back and look at the discussion, because it is really informative. And the report is also available on our committee's website.
Yep.
Thank you.
Thank you.
Thank you, Representative Hagan. Representative Thorne, did you have a question?
I do. Thank you for allowing me to speak again, Madam Chair. Just sometimes when questions get asked, it prompts more questions in myself. So my question is for Attorney General Fry. Are you aware, do you know how many law enforcement officers in Maine have been killed directly in response to a active situation?
I don't have a number of, I don't have that number.
Okay. And another question is, who in law enforcement is charged with the responsibility of keeping the officers serving under them safe, i.e. with training, tactical response, and so forth? Is that the Director of Public Safety? Would that be fair to say? And is that a focus of, and I just go back to, there's a TV show that said, let's get them before they get you.
Well, maybe the answer is a little more complex than it needs to be that I'm going to provide. So really the responsibility of ensuring that law enforcement officers are properly trained to deal with the myriad of circumstances that they confront when they're called out to a call. It's really a combined effort of, you have your required training in required topics from the Criminal Justice Academy in order to be certified as a law enforcement agency. You have the continued training that's required for the law enforcement officer to maintain their certification. That it would probably be it's a responsibility of the officer in order to maintain their certification, that they receive the training that's required. But certainly their chiefs, right? Their sergeants or their chiefs, the head of the law enforcement agency, whether it be municipal, sheriff, some other state agency that has law enforcement embedded in it, would be responsible for making sure that their officers are properly trained and maintaining their certification appropriately. I'd also add that the legislature has from time to time directed that the Criminal Justice Academy include certain trainings or that there's certain topics that are covered by the main Criminal Justice Academy that are then, that the officers are then responsible for in order to maintain their certification. So that's my attempt at a picture of different points at which, from the law enforcement officer, their commanding officer, Criminal Justice Academy, that's the responsibility for making sure that law enforcement officers are properly trained to respond to different situations that may come up when they're called out.
And then the point of where they pull the trigger is solely up to that each and individual officer as to the correct timing of that, correct? There's no training that can cover that. That they're like where they've at that point that they feel their life is in jeopardy.
Right. There is training around the use of force, which includes both non-deadly and deadly. I think if I understand your question correctly, training does everything it can to prepare officers for an infinite number of situations that they are going to be confronted with when they go out to a call. Sometimes these situations are they change at a snap, right? And so training does the best it can to make sure that officers are prepared to respond to situations, recognizing that deadly force is a last resort. But you are right that all of the training would be focused around preparing the officer for those decisions that they have to make at any given time, from, do you let the person just go with a warning, or does this require a level of force that includes deadly force?
And it's not wait until they shoot at you before you start shooting at them. It's a judgment call by the officer as to the timing of that, where they pull the trigger.
Right. Well, the training would be around the statute that has been put forward as to when a law enforcement officer is permitted to use physical force in law enforcement. And so when it comes to the use of deadly force, the training is going to be around how to evaluate whether or not self-defense is required, or to what extent force is going to be needed to prevent an escape, effectuate an arrest of a person who is believed to be engaged in crimes that may be threatening to human life. So the training is around the statute, is around what the legislature has provided for when a law enforcement officer may use force. So I don't know if that's a direct response as much as it's training that recognizes what the legislature has said is force that may be used. And yes, it is a judgment call that the officer has to make based on what they are confronted with when they're responding to a situation.
That was it. Thank you. And I lastly just want to respond to Representative Evangelos. I'm an experienced deer hunter. I've been hunting deer my entire life. And when I shoot at a running deer, a lot of times I will empty my gun and still be pulling the trigger, not knowing how many shots that I've fired at that deer, if it's still going. So, it's not like you're aware of that in that situation, let alone a life and death with another person. That's hard for any of us who haven't pulled the trigger on a human to say what your state of mind is and what you're cognizant of. So thank you, Madam Chair.
Thank you. And Representative Evangelos, I'm going to allow you to return to your questions, but I just want to remind you that the purpose of today's meeting is a review of the report of the, is a presentation of the report of the panel to review use of deadly force. And I feel like your questions are kind of turning into a deposition of the Attorney General rather than focusing on the report that's been presented to us. And I just ask you to keep that in mind as you proceed with your questions. Thank you.
Yeah. In all due respect, Senator, every single question I asked him was about the Gora case, and that is in the report. I do want to respond a minute to Representative Hagan. I mean, since I'm the only one asking penetrating questions here, I assume he's talking about me. And
actually, I'm sorry to interrupt you. Truly sorry.
Well, he's making all these negative comments. It's obviously directed at me. I'd like to respond. If you don't want me to, I won't. I'll move on.
Yeah, I would ask you to move on because in this committee, we don't argue back and forth with each other in this way, particularly when the focus of this afternoon and the purpose is to really understand the recommendations. And there are a lot of really fine and important recommendations in this report. And we've gotten very far from those recommendations. And I feel like as a committee, we should really be talking about, you know, it rests on us. This panel reports only to us. And what are we going to do with the recommendations they've made?
The hearing is to do with the annual report of the Deadly Review Panel, not just their recommendations. And I wasn't the one who started the critical stuff, but I'll move on.
Thank you.
The Brennan Institute for Justice came out with a report since George Floyd's killing, saying that many states and states' attorney generals are taking affirmative action to change the way we deal with deadly force, Mr. Attorney General. But Maine's not one of them. We're lumped in with Texas, Mississippi, Louisiana, Georgia, Florida, South and North Carolina, the Confederacy. So do you have anything to offer as to how we can reform the situation and hopefully start holding some police officers accountable when they should be?
Not having seen the report that you're referencing, these comments are going to be divorced from what you just referenced because I really can't respond to what you've read. What I can say is that I do think that, well, a couple of things. One, I more recently have tried to understand from other states what their systems are to review police shootings so that I can make an analysis of whether or not I should be advocating for some other process here in the state of Maine that may increase the level of legitimacy that the public, the legislature, others find in what I believe is a legitimate process already, but how can we make it stronger to ensure maximum confidence? We have started engaging with other states. There's actually a working group that we helped get going through the National Association of Attorneys General. States like Maine, who have in the AG's office the responsibility of looking at use of deadly force cases by law enforcement, understanding where we could be doing different things, better things. What we have found, by the way, is that Maine actually does have processes in place that allow for transparency and for ensuring that there's a complete review of a case. So in some ways, we've confirmed that we're doing okay. So I don't know about the Brennan Institute. I do think that a very important component of this is the Deadly Force Review Panel. I do want to take this opportunity to express just how much I appreciate the very hard work that all of these volunteers do to generate a really thorough review, and they engage in very thorough discussions and provide some very thorough recommendations. This is unique. This kind of panel is unique, really, in the country. And to the extent that today this committee has been presented with some significant information that it can be used to go and try to figure out how to make sure that all of our systems are operating the way they should be operating, there really is just a tremendous brain trust that's working to provide this information. And finally, if the legislature has questions about what files were used, what evidence was used to look at this, what the panel looked at, I would just remind the committee that there is a part of the statute that authorized the Deadly Force Review Panel that does allow that the legislature may inspect and review records covered by this subsection under conditions that protect the information from further disclosure. So if the committee that the panel is responding to has any questions about whether or not there was a complete review done by the panel, there is an opportunity for this committee to meet under circumstances that allow for that complete review. So I hope that's at least responsive, Representative, to the idea that I appreciate there's work to be done. I think I demonstrated that in the last session by working to get video released more quickly, tightening up the timeline for when these reports are issued. When I first came into office, I put up a lot of reports that had not been put up to provide transparency. I think I've demonstrated that I'm committed to listening to concerns when they come in, acting as best I can, and when necessary, taking steps to provide a greater level of transparency that'll only add to the legitimacy of how these cases are processed in Maine.
Thank you for that. Last line of questioning, Madam Chair. You view the role of the Attorney General's office in these cases is to represent the police officers involved, or to represent the protection of citizens' rights?
I view the role as an entity that's independent from the law enforcement agency, looking at the evidence that's generated, doing all the work that we can to make sure that we get substantive evidence, relevant evidence, and making the application of law to that. It's not in order to favor the law enforcement officer. It's not to favor the individual against whom force was deployed. It's recognizing that these are situations that the public has a significant interest in ensuring are fully investigated. And I view my office's role as making sure that the investigation is complete, the law that's been provided to me by the legislature is applied, and that there is transparency as to how it is that decision was arrived at. People aren't going to agree necessarily, I suppose. I think that's been example today. But if the lack of agreement isn't going to be because information wasn't ultimately combined and presented. So I don't see it as one side or the other. I see it as the legislature has provided when deadly force is allowed by law enforcement, I need to make a legal determination about whether or not that law was complied with.
In closing, I just want you to know, Attorney General, that the vast majority of states have identical laws that Maine does regarding the deployment of deadly force. But that hasn't stopped police chiefs, prosecutors, and attorney generals from taking action. We've seen it on the television, we've seen the court cases, and they're saying, no, you can't shoot people this way, and you're going to be held accountable. And I don't see that happening here. They have the same laws that you're citing, but that's not stopping them from saying, I'm sorry, this goes beyond what that law was, and we don't believe your story. These killings were unjustified, and we're bringing charges. And I don't see it happening here. And 0 is an operative number, sir. And the faith of Maine's people isn't being helped by that number. I think 95% of the police shootings are justified, but there's a few that weren't. And the failure to hold officers accountable is damaging to law enforcement. And that's all I have, Madam Chair.
Thank you, Representative Evangelos. Attorney General, did you want to respond to that or leave it as is?
If I may leave it as is, that's fine.
Yeah, well, it's something for us to all think about. Thank you. Committee members, we have had a really thorough discussion of the panel's report. And I think we take to heart from the members of the panel that you're reporting to us, and it's our responsibility to take your recommendations and and act on them. And we really appreciate all of your hard work. Committee members, would anybody else like to express any thanks to Vendine Vafiatis and Francine Stark for their presentation today? Okay, we're getting some Representative Harnett.
This is an incredibly difficult topic to discuss. And I want to separate, there are a lot of layers to what's being talked about, but I do want to thank both Francine and Vendine and other members of the panel for doing this work. We've heard that it takes a personal toll, and I respect and appreciate that. We all have different opinions on how to address some of these issues, and we may disagree, and I believe those disagreements come from a very good place, but I don't think there's any disagreement that we owe a debt of gratitude to the members who reported to us today on the recommendations of the panel. So I just want to say thank you for your work.
Representative Babbage.
Thank you, Madam Chair. I thought Representative Harnett was eloquent. I really cannot add much. I do want to say that I want to thank Representative Evangelos for his work over the years, actually, that has helped to bring about this panel. And I want to thank the Attorney General for his cooperation with it. I know there's still some disagreement, but there definitely has been progress, and perhaps there's more to be made. And I appreciate particularly the panel personalizing this to make us realize that there is a personal toll, because we are dealing with tragedy. And but I'm very optimistic and thankful for the participation of the folks before us. So thank you, Madam Chair.
You're welcome. I don't, Representative Moriarty? We're not able to hear you.
That's right. Thank you, Madam Chair. I do want to say that I can't do much better than my two co-chairs have done in expressing a sense of appreciation for the work done by those who have presented before us this afternoon from the panel. And so in the interest of being non-duplicative, I will simply join ranks with them and the opinions that they have expressed. Thank you.
Thank you. And I think a motion to adjourn would be in order, committee members, moved by Representative Thorne and seconded by Representative Sheehan. We will gather tomorrow morning again for more committee work. And Attorney General Francine Stark and Vendine Vafiatis, thank you so much.
Okay, thank you.